Sir Gopal Singh. DP Mahesh.
Gopal Singh, sir.
Sir, is voice clear?
Yeah.
First, there will be submissions through VC. After VC,
Okay.
there will be submissions with regard to memos in the court hall, followed by any submissions with regard to adjournments.
Any mentions through video?
Lord, page 20, serial number 57. I am seeking a short accommodation, my lord, in this matter. Any day next week, instruct.
At the request of the learned counsel for the appellant, the matter stands adjourned. Yes.
Please.
My lord, serial number 12, my lord.
Serial number?
12, my lord.
Yes.
Appearing for the appellant in this matter, lord.
Yes.
R2 and R3 has insufficient lefty address, my lord.
No, we will see when the matter reaches. There are a lot more to do in that matter. Yes. Any memos from the left side?
68, my lord.
Yes.
68.
Switch on the video, please. Switch on the video, please.
Video switch on agide.
Audio is not clear. Appear personally. Yes.
I appear for the appellant in this matter, Your Lordship.
Yes.
Petitioner is the appellant is a senior citizen, 94-year-old. In the trial court, the evidence has not been taken into thing. There is a stay which has been already granted. Matter should be disposed any day.
What is the stage of the matter?
The matter is for final hearing.
Which year matter?
22.
Not eligible. You have to move up for early. Yes.
68, my lord.
IA is pending for entry.
Yes.
IA is pending for entry. So, kindly this matter may be taken. IA is pending for
Friday. Yes.
The appellant filing memo for withdrawal. I've already filed it in the
Tomorrow.
From appellant, my lord. Filing in the 2017 matter. Last month, 15th month, but we charged in the last month.
2 weeks. Yes, any mentioning?
Admission, madam, press matter madam,
Ah.
for admission.
What is the urgency?
But they are filing execution petitions.
Have you prayed for any interim prayer? Whether any IA is pending? What other help next week? Yes, mentioning.
Page 20, serial number 50,
58.
58.
Yes.
Senior outstation of the non-question memo. Short observation. Serial number 58. For admission. Posting memo.
The request of the learned counsel for the matter stands adjourned. Yes.
Serial number 48, my lord. Actual counsel is out of station. Kindly get me. 48. For appellant. Appellant is having some inconvenience. Kindly order.
The request of the proxy counsel for the appellant. This matter on 13/7 is made clear that no further adjournment will be granted in this matter. Yes.
Your lordships kindly, my lord. Serial number 72, my lord.
Yes. Yes.
I am for the appellant, my lord. Kindly have it up 2 weeks. I have prayed for 2 weeks time, my lord.
It's old matter, 2017.
A short accommodation.
Request of the learned counsel for the appellant as a final last chance. A week's time as spread is granted. List this matter on 14/7 it is made clear that no further adjournment will be granted.
One more submission in the same matter. Can I make permitted, my lord? My lord, this arises out of a common judgment, my lord. There are 2 appeals, my lord. One is 12,018 before the single judge of this court. 12/18 of 2017 is before the division bench of this court. In view of the valuation, my lord, one came up before the single judge, another went before the division bench of this court. It arises out of a common judgment. The appellant suit is for specific performance. The respondent suit is for redelivery of possession, my lord. Now both will have to be clubbed, my lord. I may be permitted to file an application also, my lord.
Adjournment order tegiri. Do needful. The matter reaches now. Yes. All the cases. Yes.
Tomorrow I personally attend 68. I am not well today.
4 weeks time.
Make the mention the matter reaches.
For being spoken to, serial number 1, A. Kumarvel, Venkatesh Prasada, correspondent.
An application for raising the amount, my lord, under the provisions of 148 of the MI Act, my lord. This honorable court by its order dated 15/12/2022, my lord, was pleased to allow my application. And one the mistake agida 37
1 minute.
lakhs that should be read as
1 minute. The application. I have to. No objection for this IA.
My senior brother expired. 11th ceremony, Mandala Samaya.
Current counsels from both sides present. Current counsel for the petitioner submits his no objection to allow you 1/23. Peruse the IA filed under section 482 CRPC, wherein the respondent has paid for rectification of the total rectification of the figure of the amount to be released in his favor from rupees 37 lakh to rupees 13 lakh 75,000. From the perusal of the IA 2/2022 and the order dated 15/12/2022, it is clear that the amount said to have been deposited by the accused is only a sum of rupees 13 lakh 75,000. However, by typographical error, it has been typed as rupees 37 lakh. As such, the rectification sought for request to be effected, for which IA 1/23 deserves to be allowed. Accordingly, IA 1/23, the road in part and the amount to be released, which is shown as rupees 37 lakh in the order dated 15/12/2022, is to be read as rupees 13 lakh 75,000. Further, in the same order, the allowing of the IA number is shown as IA 2/2002 in page 2, last paragraph. The said IA number also is to be read as IA number 2 of 2022. Barring the above, there would be no other alterations or corrections in the order dated 15/12/2022. Yes.
On complaints of office objections, fifth time, serial number 2.
ನಾನು ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ದೆ, ಮಾಡಲಿಲ್ಲ ನೀವು 2022 IA ನಂಬರ್ ಅಲ್ವೇ? ನಿಮ್ಗೆ ಹೇಳಿದಲ್ವೇ? ಹಾರ್ದಿಕ್ ಹೇಳಿದ್ದ, ಆಮೇಲೆ ಕೇಳಿ ಹಾಕಿನಿ, ಯಾಕೆ ಕೇಳಿಲ್ಲ?
On complaints of office objections, fifth time, serial number 2, LV Muralidhara.
My lord. My lord. The main objection in this point, in this case, is that with regard to the valuation of the property, even in other case also, the same property was involved. Our contention is that the property value is zero.
Mr. Counsel,
as per the market condition.
You have taken 5 adjournments to comply of his objection. If any submission were to be there, you should have made it on the very first instance. Very first instance. The valuation is not the only one objection. There are several other small trivial office objections also, which you have not at all attended.
2 minutes I want.
Yes, please.
My lord, I have gone through, I have come on record recently. Just, I have not been able to discuss properly with the appellant. And here, I have gone through the earlier file. Even the trial court also, this case is not maintainable. Even appeal is also not maintainable. So kindly allow me just 2 days time. I will submit proper application to decide this. After, if the honorable court permits me to continue this case, then I will make all the objections attended. I will attend all the objections.
According to you, appeal is not maintainable. File a memo of withdrawal right now.
Just give me 2 days. Because he is not.
Absolutely not.
Well, he is not well. That is the reason. I have not been able to discuss this. I suggest him to withdraw this case. Kindly 2 days, just 2 days.
The learned counsel for the appellant stating that he is withdrawing the case as the same is not maintainable, pays for 2 days accommodation. The result of the order sheet would go to show that several and subsequent opportunities of not less than 5 times have already been granted, despite which the appellant has not complied with the office objection. As such, though the appeal could have been dismissed for non-prosecution and dismissed for non-compliance of office objection, however, considering the submission made today as an ultimate opportunity, 2 days time as spread is granted. Please the matter on 12/7.
Much.
In case if the needful is not done, the court would proceed to pass appropriate order, including yes.
Bill number 3, Basaraj DP.
Place of audience. Telecast.
ಯಾವಾಗ ಕಟ್ಟಿದ್ದೀರಿ?
Acknowledgement NFI.
ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಯಾಕಷ್ಟು ಸಮಯ ತಗೊಂಡ್ರಿ?
Yes, ಮಾಡ್ತಿದ್ದೆ. Close ಆಗುತ್ತೆ.
Counsel for the appellant submits that he has filed. Proceed with the complaints memo in the registry. ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ದೀರಿ ಅದನ್ನ? On 4/7/2023. Registry to verify and proceed. If not complete, list this matter on 14/7. Yes.
Serial number 4, Pranidhara CV.
Last 500 on the 300. 300.
ಹೀಗೆ ತಗೊಳ್ಳಿ ಇದನ್ನ. In case of non-compliance of the order dated 3/7/2023 within the time granted in its entirety, the appeal stands dismissed on its own without any further order by this court. With immediate. ಅದನ್ನು 14/7 ತೆಗೆರಿ, registry to verify and proceed ಅಂತ ಮಾಡಿ. If not complete in its entirety, including deficit payment of the cost also, the appeal stands dismissed on its own without any further order by this court for not doing needful in the matter. Not compliance of the direction. Immediate effect. Yes.
Serial number 4, Pranidhara CV.
My last. I may kindly be permitted to withdraw this case.
Purpose for the appellant to physically present. For the submission of a 1/23. Filed under Order 23 Rule 1 of CPC. It is said that he has prayed for permission for withdrawal of this appeal as not trust. In view of the memo supporting submission, the appeal stands dismissed as not trust. Yes.
Cell number 5, Sri Ratnakshi.
Also for the appellant neither present physically nor through video conference. 2/6/2023, this court amends the following observation. Right of the appeal. The appellant has neither completed the officer nor did appear. 4/7/2023. That was again taken. Does it really go to show that the appellant has neither interested in prosecuting the appeal nor complying with this objection, nor even in making any submission regarding the jurisdiction? As such, the appeal stands dismissed for non-compliance of office objection and non-prosecution. Yes.
Cell number 6, Harish Kumar MS.
Not less than 5 times opportunity in practice. 100%.
Valuation that I was reading. Words. 1992.
Counsel for the appellant is physically present and submits that despite his effort, could not lay his hand with respect to any of the documents to ascertain the valuation of the social property. As such, he is unable to comply with his objection. Next one. When the appellant himself has considered that he is unable to comply with the office objection and his client couldn't furnish him the necessary details or the documents to comply with the office objection, the matter cannot be proceeded further. Several insufficient opportunities of not less than 5 times were granted to the appellant to comply with office objection, despite which office objection. However, after taking sufficient opportunities, the appellant, since now expresses his helplessness to comply with his objection, the appeal stands dismissed for non-compliance of office objection. The delayed payment of cost is accepted. Yes.
Seal number 7, Jwala Kumar.
Yesterday I filed in the memo.
Counsel for the appellant submits that needful done, register it, verify and proceed if needful is not done in its entirety. List the matter on 14th.
Seal number 8, Vasant Kumar.
For the appellant. Permit me to move.
Memo for what?
My lordship, there is a clarification regarding the valuation, my lordship. Plaintiffs of paid 200 rupees under section 35(2) of KCF as the plaintiff is paid.
Who permitted you to change the memorandum of appeal in the guise of
My lordship, here.
rectification or the compliance of office objection?
Corrections, there are a couple of typographical errors, my lordship. There were corrections being made in that effect.
How can you substitute a memorandum of appeal with another one without the leave of the court?
A couple of change of typographical error, my lordship. Now, there are a lot of more error was there, my lordship.
Further submission of learned counsel for the appellant.
If you permit me, my lordship.
The registry has shown that
By the memo of the Withdrawal seeking a report to file a fresh my lordship. Thank you, my lordship.
that during the compliance, the counsel for the appellant has changed the appeal memorandum. The learned registrar judicial to make a submission in writing as to on what basis the appellant was permitted to substitute a memorandum of appeal with a new one without the leave of the court. Please the matter on 12/7.
This time non-compliant. Seal number 9, Pradeep C. Patil.
Appellant. These are cost on 24/6. Of course, they are reversing, but it does not give on 21/6.
There are counsel for the appellant who is physically present, repeatedly submitting only about the delayed payment of the cost by him, but not about the non-compliance of office objection. Perusal of the
Permitted to withdraw the
memo file ಮಾಡಿ. Otherwise, I dismiss with exemplary cost of 5,000 rupees. At this stage, the learned counsel prays to pass over the matter, stating that he would not press the appeal and he would withdraw the same. Matter stands possible.
Order fact, serial number 10, Giridhar Sri.
For the respondent number 3, my lords.
I appear for the appellant in the matter. Lords, I have filed the objections on the 1st of July 2023. I have sent a copy of the objections to the counsel appearing for the respondent by post.
Received the
I've still not received it.
I'll serve it again, my lords. May I request permission to comply during the course of the day?
The counsel for the appellant is physically present and submits that he has filed his objection to the memo dated 14/5/2023 and sent a copy of the objections to the learned counsel for the respondent number 3.
Respondent number 3.
Learned counsel for respondent number sent a copy to the learned counsel for respondent number 3 by post. However, learned counsel for respondent number 3 submits about non-receipt of the said copy of objection. Counsel for the appellant submits that he would furnish a fresh copy of the objection, one more copy of the objection to the said learned counsel. 2 days time is granted.
Great.
Pleasure.
Hey, Jayaprakash Rao, T. Seshgiri Rao, State of Respondents.
Seat number first one. The place of office number. Chief Justice member, place of office number. Okay, warning number, I don't copy.
So for the appellant alone present. There is no submission. To the learned registrar general. The matter stands passed over.
Number 12.
I prepare the appellant in this matter.
Gopal Singh.
ತಗೊಳ್ಳಬಾರ್ದು ತಗೊಂಡಿದೆ ಇವಾಗ ಯಾಕೆ ಕಳಿಸ್ತಿಲ್ಲ ಅವ್ರು ಬಂದು ಕೇಳಬೇಕು ಡೈರೆಕ್ಟ್ ಮಾಡೋದು ಅವರಿಗೆ ಏನಾಯ್ತು ನನಗೂ ಒಬಿಡಿಯಂಟ್ ಆಗಿರೋದು ಅನ್ಕೊಂಡಿದ್ದೆ ಬೇರೆ ಸ್ಟಾಫ್ಗಳಿಗೆ ಮಾಡಿದಾರೆ ಮಾಡಲಿ ಅದೇನು ಮಾಡ್ತಾರೆ ತಗೊಂಡು ಮಾಡಲಿ ಅಷ್ಟೆಲ್ಲ ಮೂವತ್ತು ತಗೊಂಡು
Cell number 12. Gopal Singh.
I prepare the appellant in this matter.
My lord, on the appellant connected matter RFA 76 of 2007, in which I have complied all the, I furnished the paper book complied.
counsel for the appellant. Only the submission. The counsel for the appellant in RFA 756 of 2017, who is physically correct. It's no further submission except stating appearing for the appellant. It's a matter to not be.
They appear for the first respondent.
Yes, Prasanna Kumar.
First respondent by me.
Regarding they are unable to ascertain the year 18 June what they remember. Settle on R5 narco RK or the
To whom you have taken steps, when you have taken steps. We will reject that. We will reject that. ನಾನು ಕಷ್ಟಪಟ್ಟೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೇನೆ ಯಾಕೆಂದ್ರೆ ನಾನು ಬರಿಬೇಕು ಯಾಕೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಿದ್ದೇನೆ ಅಂತ ವಕೀಲರೇ ಸಂಬಂಧ ಇಲ್ಲದೆ ಸಬ್ಮಿಷನ್ ಮಾಡಬೇಡಿ ಅದ್ಯಾವುದು ಈಗ ರೆಲೆವೆಂಟ್ ಅಲ್ಲ ರೆಲೆವೆನ್ಸಿ ಇರೋದು 6 ವರ್ಷ ಆದ್ರೂ ಅಡ್ವೊಕೇಟ್ 25 ರೂಪಾಯಿ ಕಟ್ಟಲಿಲ್ಲ ಅನ್ನೋದು ಅದು ನಿಮ್ಮ ಕ್ಲೈಂಟ್ಗಳು ಜವಾಬ್ದಾರಿ ತಗೊಳ್ಳದವರು ನೀವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಪಾಪ ಅಷ್ಟೇ admittedly the appellant was directed to take steps for a particular date on 26/2023 has not taken steps within the said date. Hence the appeal as against respondent number 2, 3 and 5 stands dismissed for not taking step. In view of the above, the maintainability of the appeal as against the remaining appellants is required to be heard at the appropriate stage. Yes.
Number 40. CR Sandesh, amicus curiae. HR Uma Devi for Kevata respondent to.
None appear in this matter either physically or through video conference. If the learned amicus curiae appointed for the appellant also has remained absent. 1/4/2004. Noticing that the sufficient opportunity was given to the appellant for compliance of office objection despite which needful had not been done, this court had ordered for issuance of court notice to the appellant. Accordingly, for the judgment made by the registry, the appellant has been served with the court notice. The appellant called out. Yes.
Venkatraju.
Has remained absent. Thus, despite the service of court notice also, neither the appellant nor the amicus curiae nor the previous counsel for the appellant are evincing any interest in prosecuting the matter. Perusal of the order sheet will go to show that in this appeal of the year 2017 till date, the appellant has not complied with the office obstructions. Thus, it is a clear case where the appellant is neither interested in prosecuting the matter neither interested in complying with the office obstruction nor in prosecuting the matter. The court has also taken all precaution to ensure the court has also taken precaution and got issued a court notice also to the appellant, despite which there is no response. Hence, the appeal stands dismissed for non-compliance of office objection and for non-prosecution. Yes.
Still number 15. Yes, Kalyan Basuraj.
Already one recorded honorable court panel. Out of record matter.
Force liquid. 6 hours. That was placed before the CGCJ and the following observation. There are counsel for the appellant. Present. The registry has not made its submission as to whether the direction given to the learned registrar general to place the matter before the Honorable Chief Justice of this court was complied with, and the observation made by the Honorable Chief Justice, if any, registry to make its submission. Call the matter at 2:30 p.m. Yes.
Still number 16.
Next connected matter. You cannot maintain a memo. I have passed several such order in your office matters only, but still you are continuing the same practice. Probably I am going to pass a serious order this afternoon. Tell your senior. Yes.
Still number 21. Nandish Patil.
ಎಲ್ಲರೂ ಸೇಮ್ ಆರ್ಡರ್ ರೀ ಎಲ್ಲರಲ್ಲೂ ವಾರ್ನಿಂಗ್ ಮೆಮೋ ಇದೆ, ಅದನ್ನು ಹೇಳಿ, ಅರ್ಧಂಬರ್ಧ ಹೇಳಬೇಡಿ. ಬರೀ ಕಲ್ಯಾಣ ಬಸವರಾಜ್ ಅಷ್ಟೇ ಅಲ್ಲ, ವಾರ್ನಿಂಗ್ ಮೆಮೋ ಇರೋದು ಮಾತ್ರ ನಾನು ಜಡ್ಜ್ ಮಾಡ್ತಿರೋದು. ವಾರ್ನಿಂಗ್ ಮೆಮೋ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು, ನೀವು ಅವ್ರು ಅದೆಲ್ಲ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು, ಮಾಡಿ ಕಳಿಸ್ಬೇಕು.
Serial number
ನೆಕ್ಸ್ಟ್ ಕರೀರಿ.
serial number 21, Nandish Patil.
The appellant this morning, I have paid the cost. For us to getting a paper, getting a memo saying distinctly matter of
Memo won't do. Kindly discard the practice of filing memo where an application is required to be filed.
I will.
That is one of the worst practice prevailing in Karnataka High Court. I do not know why. Probably many of the councils are required to go to the civil court once and see what the procedure is. Easiness or convenience itself is not the practice. What is the legal sanctity of a memo? Come on, tell me. Which law defines us what memo is? Seniors does it. Youngsters follow the same thing.
Application.
Yes.
The matter arises of dismissal of the rejection claim on an application under order 7/11. TCR has come to this court. Therefore, paper book not necessary anta ನನ್ನ ಅಭಿಪ್ರಾಯ. I will make an application.
ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಿದ ಮಾಡುವ. ಕೆಲವುದು ಕೇಳಲ್ಲ, ನಮಗೆ ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? ದೇವ್ರು ಹಾಗೆ ಹೇಳಿದಾನೆ, ಕೇಳಂತದ್ ಮಾತ್ರ ಕೇಳ್ರಿ, ಉಳಿದದನ್ನ ಬರೀ ನೋಡಿ ಅಂತ.
I do that.
Yes.
So far as one more applies in respect of taking steps for the deceased R6 is in Hoskote. Still one more accomplished.
Deceased R6 is in Hoskote.
Deceased was in Hoskote. I want to send my client ascertain the detail. Large application active.
The counsel Sri so and so, who is physically present, submits that he has filed his no objection wakalat in the matter only today.
What's the state?
Submits at the cost imposed.
Long time cost was not paid.
No. I am saying, ಅದಕ್ಕೆ ಚಕ್ರ ಬಡ್ಡಿ ಹಾಕ್ಬೇಕಲ್ವೇ?
ನೋಡಿದೆ ಸ್ವಾಮಿ.
ನಿಜವಾಗಿ
21ರಿಂದ ಕಟ್ಟಿಲ್ಲ.
ಹೌದು, ನಾನೇ ಹಿಂದಿನ ರೋಸ್ಟರ್ ಅಲ್ಲ, ಅದ್ರ ಹಿಂದಿನ ರೋಸ್ಟರ್ ನಲ್ಲಿ 2.5 ವರ್ಷದ ಕೆಳಗೆ ಹಾಕಿದ್ ಕಾಸು.
Unfortunately, council has.
ನಿಮ್ಮ ಅನ್ಫಾರ್ಚುನೇಟ್ ಅಲ್ಲ, ನನ್ನ ನತದೃಷ್ಟತೆ ನೋಡಿ. ನಾನ್ ಮಾಡಿರ್ತಕ್ಕಂಥ ಆರ್ಡರ್ಗಳು ಮತ್ತೆ ನಾನ್ ಬರಲಿವರೆಗೂ ನಿಷ್ಠೆ ಆಗಿರಲ್ಲ. ಅದು ನಾನೇ ಬಂದು ನೋಡಿ ಅದು ಏನಾಗಿದೆ ಅನ್ನೋದು ನೋಡ್ಬೇಕು. ಇದಾದ್ರೂ 2021, 2017 ಬರ್ತಾ ಇದೆ. ನೋಡಿದ್ರೆ ನನ್ನ ಆರ್ಡರ್, ಆಮೇಲೆ ಮತ್ತೆ ನಿಷ್ಠೆ ಮಾಡ್ಲಿಲ್ಲ ಅವರು. ಅದು ದುರದೃಷ್ಟವಂತಿಕೆ ಅಂದ್ರೆ ಅದು. ಇದಕ್ಕೆ ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಕಾಸ್ಟ್ ಹಾಕುವ. ಎಷ್ಟು ಹಾಕ್ಬಹುದು? ರೀಸನಬಲ್ ಅಮೌಂಟ್ ನೀವೇ ಹೇಳಿ ನೋಡೋಣಂತೆ. ಫಾರ್ ದ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಫ್ ದಿ ಡಿಲೇಡ್ ಪೇಮೆಂಟ್ ಆಫ್ ದಿ ಕಾಸ್ಟ್. ದಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪಲೆಂಟ್ though submits that the cost imposed on 16/12/2021 has been paid by the appellant but admittedly the same is after lapse of more than 1.5 years. As such, the acceptance of the delayed payment of the cost would be by imposing an additional cost of ₹300 by the appellant payable to the Legal Services Committee of this court before this forenoon session and filing a compliance memo along with receipt to that effect in the registry.
For the end of the day.
ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಕಳಿಸಿ, ಹಿಂದೆ ನಿಂತಿದ್ದಾರೆ ನಿಮ್ ಕ್ಲೈಂಟ್ ಅಲ್ವೇ? ₹300 ಕಾಸ್ಟು, ವಕೀಲರು ಕೂಡ ಫೀಸು, ಎರಡು ಸೇರಿಸಿ ಕೊಡಪ್ಪ ಈಗಲೇ. ನಿಮ್ ಫೀಸ್ ಇದು ಹೇಳಿದೀನಿ. ಯು ಮಸ್ಟ್ ಬಿ ಹ್ಯಾಪಿ. ಎಸ್, ಏನಾಯ್ತು?
Filing a complaint memo and receipt to that effect in the registry.
The counsel prays for a week's time to take appropriate steps with respect to the deceased respondent number 6. The final last opportunity, a week's time as credit is granted. Yes.
Serial number 22, Srikanth S.
Either physically or through video conference. No reasons of outcoming for non-appearance of the learned counsel for the appellant. The result of the order sheet would go to show that several sufficient opportunities were granted to the appellant to comply with this objection. On 28/5/2021, the following order was thereafter, on 18/6/2021, thereafter, on subsequent dates of hearing, the following orders were made by this court. Right of the above, after the note put up by the registry, the counsel for the appellant has not complied with the office objections. No reasons of forthcoming are either for non-appearance of the learned counsel for the appellant or for non-compliance of office objection. Hence, the appeal stands dismissed for non-compliance of office objection as well as for non-prosecution. Yes.
Cell number 23, H.V. Shamegowda.
One appearance finally to which time is correct.
Cell number 24,
To be needful.
Suresh P. 24.
Appear for the appellant either physically or through video conference. On 23/6/2023, this court had made the following observation. In spite of the same, the appellant has not taken first steps with respect to unserved respondents, including respondent number 1, 2, 4 in IA 1/2017. And steps and not taken steps with respect to respondent number 3 and respondent number 5. This clearly goes to show that the appellant is not evincing any interest to prosecute the appeal, which is one of the oldest appeals, which is of the year 2017. Hence, the appeal stands dismissed for non-prosecution and not taking steps. Yes.
Cell number 25, Arun R. Court.
Counsel for the appellant submits that he has taken steps and done needful on 4/7/2023. Registry to verify if steps are not taken. List the matter on 17/7. If the steps have already been taken, registry to proceed further.
Cell number 26, Shankar Lingappa Nagaraj.
None of here. Finally, 3 days time is granted to the appellant to take first steps to ensure the service of notice upon all the unserved respondents. Failing which the court may proceed to pass appropriate order to unserved respondents and with respect to the deceased respondents. Failing which the court would proceed to pass appropriate order, including dismissal of the appeal as against those respondents. If needful is not done, registry to reach this matter. On 14/7. Yes.
Serial number 27, B. Palakshaya.
And for the appellant, my lords, I have filed an application for paper publication. Since R3 has left and R1 is not known.
Once again, take steps afresh. Ascertain the correct address is possible.
ಅಲ್ಲಿ ವಿಚಾರಿಸಿ ನನ್ನ ಕ್ಲೈಂಟ್ ವಿಚಾರಿಸಿ ಹೇಳಿದಾರೆ ಅಲ್ಲೇ ಇದಾರಂತೆ ಆದ್ರೂ ರಿಸೀವ್ ಮಾಡ್ಕೊಂತ ಇಲ್ಲ ಮತ್ತೆ R3 ಹ್ಯಾಸ್ ಲೆಫ್ಟ್ ದ ಪ್ರಿಮೈಸಸ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ R3
ಇನ್ನೊಮ್ಮೆ ನೋಟಿಸ್ ತಗೊಳ್ಳಿ ಅಲ್ಲೇ ಇದ್ದಾರೆ ಆದ್ರೂ ತಗೊಳ್ತಿಲ್ಲ ಅಂದ್ರೆ ಸ್ಟ್ರೈಟ್ ಅವೇ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಳ್ಳಿಕ್ಕೆ ಬರೋಲ್ಲ.
ಆಯ್ತು ಸ್ವಾಮಿ ತಗೊಂತೇನೆ
ಇನ್ನೊಮ್ಮೆ ತಗೊಳ್ಳಿ
ಪ್ಲೀಸ್.
Counsel for the appellant is appearing through video conference, heard his submission. Since has taken only once since has taken steps only for once as against respondent number 1 and 3. Keeping in abeyance his IA. ಯಾವ್ದ್ರಿ ಅದ ಇದು ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸ್
2023 my lords.
Complaint, non-complaints of opposition based on IA.
One got 23. The appellant is directed to take first steps once again to respondent number 1 and 3 by ascertaining the exact complete and present address.
May I make one more request, my lords?
Yes.
Another appeal arising out of the common judgment is filed, which is 1285 of 2017. In 2017, respondent number 1 is represented by a counsel. As far as respondent number 1 is concerned, I may be permitted to serve a copy on the counsel.
6 ವರ್ಷ ಬಿಟ್ಟು ಹೇಳ್ತಾ ಇದ್ದೀರಿ ಬಹಳ ಬೇಗ ಆಯ್ತು. 6 ವರ್ಷ ಬಿಟ್ಟು ಹೇಳ್ತಾ ಇದ್ದೀರಿ ಬಹಳ ಬೇಗ ಆಯ್ತು.
I am extremely sorry, my lords.
ಇದೇ ದುರಂತ ಇದೆ ನಮ್ಮಲ್ಲಿ. ಯಾವ್ದು ಅರ್ಲಿಯಸ್ಟ್ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಮಾಡ್ಬೋದು ಸಬ್ಮಿಷನ್ ಅದು ನನ್ನಂತವ್ರು ಬಂದು ಕೂತು ಬಹಳ ಸ್ಟ್ರಾಂಗ್ ಆರ್ಡರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಶುರು ಮಾಡಿದ್ರ ಮೇಲೆ ಆಮೇಲೆ ಹೇಳೋ ಬೇಕು ಬೇಡವೋ ಅಂತ ಹೇಳಿ ಮಾಡ್ತಾರೆ. ಇವತ್ತು ನೀವು ಹೇಳ್ದಂಗೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಅನ್ನು ಅಲೋ ಮಾಡಿದ್ರೆ ಖುಷಿಯಿಂದ ಸುಮ್ನೆ ಎತ್ತಿದ್ರಿ, ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ದು ಹೇಳ್ತಾ ಇರ್ಲಿಲ್ಲ. ಆಮೇಲೆ ಇನ್ಯಾವಾಗ್ಲೂ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬಂದು ಎಲ್ಲದೂ ಆಗಿ ಇನ್ ಅಡ್ಜರ್ಮೆಂಟ್ ಕೋರ್ಟ್ ಕೊಡಲ್ಲ ಅಂತ ಆದಾಗ there might be a connected appeal. I am told by my client only today morning I will make submission. Kindly grant me 2 weeks time ಅಂತಿದ್ದೀರಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ ಅದನ್ನ
ವಾಲ್ಯೂಮ್ 14 ವಾಲ್ಯೂಮ್ ಬರಿಬಹುದ್ರಿ. ಕೇಸ್ಗಳು ಹೇಗೆ ನಡೀತಾವೆ ಹೇಗೆ ನಡೆಸ್ತೀರಿ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ
ಅನ್ಡೌಟೆಡ್ಲಿ
ಬೇಜಾರಾಗ್ತದೆ. ಅಪತಿ ಏನ್ ತಗೊಂಡ್ರಿ?
Keeping in abeyance IA 1 of 2023.
Is directed to take first notice once again to respondent number 1 and 3 within 3 days from today by ascertaining the correct, complete and present address. Next line. The learned counsel for the appellant submits that. Which is that another RFA?
1285 of 2017.
RFA 1285 of 2017 is also a connected matter with this. However, the appellant is directed to take fresh steps in the matter. In case if needful is not done, registry to list this matter on 18/7. Yes.
Serial number 28, NR Naik, same Nagabhushan for respondent connected.
ಡೇಟನ್ನು ಸರಿ ಬರೀತಿಲ್ಲ, ಏನು ಮಾಡ್ತಿಲ್ಲ,
ಹೇಳಿದೆ.
ನಿಮ್ಗೆ ಸತ್ಯ ಹೇಳಿದ್ದೇನೆ. ಮಧ್ಯಾಹ್ನ ಆತನ ಎಳ್ಕೊಂಡ್ ಬನ್ನಿ ನಮ್ಮ ಚೇಂಬರ್ಗೆ. ಯಾರು ಬರ್ದಿದ್ದಾರೆ ಇವ್ರ ಮೇಲೆ ಯಾರಿದ್ದಾರೆ ಅವ್ರಿಬ್ರು ನನ್ನ ಚೇಂಬರ್ಗೆ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ. ಯಾಕೆ ಅಂತ ಹೇಳಿ ನನಗೆ ಇವ್ರು ಹಾಕೋ ನೋಟ್ ಇವರೇ ಅಂತ. Counsel for the appellant neither present physically nor through video conference. For the K-weight or alone is present. The result of the order sheet will go to show that these appeals of the year 2017. The appellant is not evincing any interest to ensure the service of notice upon the unserved respondents, which is greatly contributing for the delay. The proceeding further in this appeal. Connected to the Mutagiri order sheet last. On the previous date of hearing also, the counsel the appellant had remained also. Hence, for not taking steps, the appeal as against respondent number 2. All these appeals stands dismissed. In view of the dismissal of the appeal as against respondent number 2, the maintainability of the appeal as against respondent number 1 alone is required to be heard at the appropriate stage. Yes.
Set number 29, Manjunath HR, P. Ravichandra for respondent.
Paper copy, 4 weeks time.
Requested for by legal counsel for the appellant has finally 4 weeks time is granted.
Cell number 30, BS Govindaswamy.
Yes, sir. Which time? Connected CRP, my lord, I took paper publication also, my lord. In that aspect of service of paper publication, they have not appeared. CRP is something about 2007.
Counsel for the appellant who is physically present tries for some more time to take fresh steps to ensure the service of notice upon unserved respondent number 1 and 2. Whereas of the order sheet would go to show that the appeal is of the year 2017 and the emergent notice was ordered for the respondents as long back as on 11/8/2017. On the very same day, the appellant was also granted with an interim prayer of stay. The appellant is enjoying the said interim order, however, is not evincing any interest to ensure the service of notice upon unserved respondents, though the nature of the notice ordered was emergent in its nature. Therefore, the time as prayed is granted, however, vacating the interim order of stay granted on 11/8/2017. It was further extended on 7/9/2017. Yes.
Cell number 31, BS Manjunath.
3 days time.
Register with the
Deposit will be.
warning. Here is the submission of register of the material. When you first did it, warning minimum and yes, please.
2 days time.
Counsel for the appellant prays for. Each time, the time as paid is granted to deposit the cost of the approximate cost of the paper.
Cell number 32, Prithvi Wadia.
For retirement.
Probably this is not the acknowledgement given by them or acknowledging your retirement.
Appellant number 1 and 2 has taken papers along.
ಹೌದ್ರಿ ನೀವು ಹೇಳಿದ್ದೀರಿ ಬಟ್ ಅದನ್ನು ನೋಡಿದ್ರೆ ಅವ್ರು ನಿಮಗೆ ರಿಟೈರ್ಮೆಂಟ್ಗೆ ಕನ್ಸೆಂಟ್ ಮಾಡಿ ಸೈನ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಅನ್ಸಲ್ಲ.
NOC ತಗೊಂಡು ಅದಕ್ಕೆ ನಾವು ರಿಟರ್ನ್ಮೆಂಟ್ they have taken NOC along with all the papers, the other collection, behalf of the other appellants.
You issue them a notice. There are more than 2 appellants.
On behalf of the other appellants also.
They can't. You issue them the notice.
Yes.
The signature doesn't appear to be say that knowing that they are permitting you to retire, they have signed.
Issue notice.
For the submission of learned counsel for the appellant. There was a memo of retirement filed by him. We are reading and look of the memo of retirement and the places of the signatures obtained of the alleged appellants number 1 and 2 does not inspire confidence to believe that the appellant who was shown to have signed in the said memo were aware of the nature of the memo or the recitals therein. Furthermore, admittedly, the appellant number 3 and 4 have not signed the said memo as such. They have not permitted their learned counsel to retire from appearing for them in the matter. Hence, the memo of retirement stands rejected. Finally, 4 weeks time is granted to file paper.
Till number 33, PV Ravindranath.
Certain correct address and take steps. Cross-reference incomplete address. Whatever is stated in the lane to that address it was.
The request of learned counsel for the appellant as finally a week's time is granted to ascertain the correct, complete, and present address of unserved respondent and to take first step. Yes.
34, V Vishwanath Shetty.
Respondent 1 and 2 are applicable.
ಮೆಮೋ ರಿಟೈರ್ಮೆಂಟ್ ವಕಾಲತಿಗಳು ಫ್ಲಾಟ್ ಕಟ್ಟಬೇಕು ಅನ್ನೋಷ್ಟು ಇಲ್ವಾ? ಇಬ್ರು ಇರ್ತೀವಿ. ನಾಳೆಯಿಂದ ಒಬ್ಬರೇ ಇರಿ ನನ್ನ ಫೋಟೋಲ್ಲಿ, ಇನ್ನೊಬ್ಬರನ್ನ ಕಳಿಸಿ ಬಿಡಿ ವಾಪಸ್. ಏನು ಕೆಲಸ ಇಲ್ಲದೆ ಅಡಿಷನಲ್ ಯಾಕೆ ಇರ್ಬೇಕು? ಏನು ಕೆಲಸ ಇರ ಮಾಡಂತದನ್ನು ಒಬ್ಬರೇ ಮಾಡಿದ್ರೆ ಸಾಕು, ಅವರು ಮಾಡಲ್ಲ. ಅಥವಾ ನೀವು ಇಬ್ರು ಬೇಡ, ಹೋಗಿ ಫೈಲ್ಗಳನ್ನ ಇಲ್ಲಿಡಿ, ನಾನು ಅಟೆಂಡ್ ಮಾಡ್ತೇನೆ, ನಿಮ್ಗಿಂತಲೂ ಚೆನ್ನಾಗಿ ಮಾಡ್ತೇನೆ. ಮಕ್ಕಳಿಗೆ ನಾಚಿಕೆ ಆಗ್ತದೆ ರೀ ಕೇಳಿಸ್ಕೊಂಡ್ರೆ, ಒಂದಲ್ಲ ಎರಡನೇ ಸತ್ಯ ಹೇಳಿಸ್ಕೊಂಡ್ರೆ ಮಕ್ಕಳಿಗೆ ನಾಚಿಕೆ ಆಗ್ತದೆ. You have no objection.
No objection.
Learned counsel from both sides physically present. Produce the memo dated 7/3/2022 filed by the apparent, heard submission from both sides. In view of the memo supporting submission, the appeal stands dismissed as not pressed. Yes.
Silver 35, yes, sir.
You are not eligible. Yes.
At the paper.
As requested for by learned counsel for the appellant, as finally 3 weeks time is spent to file paper.
36, RB Sadashivappa.
As requested for by learned counsel for the appellant, 2 weeks time is granted.
37, Suresh Kumar HM.
Yes, by for retirement. Name may be kindly be removed from here and that.
Who are you whom you are appearing?
Appellant. This was the Balakrishnan. Appellant number 1 and 2 used to apply.
You are not the present counsel.
File memo for retirement.
Present counsel who is Suresh Kumar.
Suresh Kumar HM for appellant number 1.
Learned counsel Sri Suresh Kumar HM for the appellant and the learned counsel for respondents not present. Learned counsel Sri G. Balakrishna Shastri alone present. and make submission on the lines of his memo of requirement. Next, in view of the fact that the appellant has engaged the services of the present counsel for him with no objection whatsoever, the learned counsel Sri G. Balakrishna Shastri is permitted to retire from appearing for the appellant in this matter. Yes.
Bill number 38, Raghu Prasad PS.
That I need to file clarification. Can you pay for a week's accommodation? Along with that, I'll file the paper.
Voting debt query. Further for the appellant present. For non-compliance of office objection on ID 1/23, the said IA stands returned to the applicant. With the matter in the list. Yes.
Seal number 39, R. Nagendra Naik.
For the appellant.
What need to you have the
File the paper.
counsel for the appellant submits. You to done the matter. Registry to the. Yes.
Seal number 40. K. Venkatamani Shetty.
None appear in this matter. As a matter could not be proceeded.
Seal number 41, Suresh Babu.
Learned counsel from both sides present. Is the matter on 7, 8. Yes, come on, 7, 8.
Number 42, Nagaratna SK, Shivkumar V for Kevata respondent.
Also for the appellant is physically present. Measure submission. Seeking permission for withdrawal of this appeal. The result of the more dated 3/7/2023 go to show that alleging some settlement, the appellant is shown to have paid for permission to withdraw the appeal. The said memo is shown to have been signed both by the learned counsel for the appellant and by the appellant. However, the wakalat right go to show that the appellant has put her subscribed her signature to the wakalat in Kannada language, whereas the memo bears an unidentified LTM. Hence, the said memo cannot be accepted. Accordingly, the said memo stands rejected. However, with a cost of ₹500 for not properly utilizing the precious time of the court. The cost is payable by the appellant to the Legal Services Committee of this court within a day from today. 5. A compliance memo along with original receipt to that effect in the registry within the said time. The matter on 14/7. Yes.
What, number 43, Patil Dayanand.
Our madam. I'll take memo for dispensation. The respondent number 5. Also, experience, therefore I hold it. Is a plaintiff under 4 before trial court. I am not filing any relief against our file. Therefore, I filed memo for dispensation.
That was execution from direction to the department. Direction to the register. Notice ಆಗಿಲ್ಲ. Why they have asked for PM? Means interim order is issued. Notice is due to. Therefore, they have asked for.
of the memo dated 28/6/2023 and the supporting submission made by the learned counsel. For the appellant, the note point number 5 stands dispensed with, however, the consequence and risk of again about the problem. When you have taken steps for unserved respondent number 2, date ಬೇಕು ನನಗೆ ಡೇಟ್ ಮೇಲೆ ಎಲ್ಲದೂ ಡಿಪೆಂಡ್ ಆಗಿದೆ.
Please, madam. Misplace ಮಾಡ್ಬಿಟ್ಟಿಯಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಡೇಟ್ ಹೇಳಕ್ಕೆ ನಾನು ಡೇಟ್ ಹೇಳ್ತೀನಿ ಸರ್. ಆ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಹಾಕಿದ್ದೀನೇ ಮೇಡಮ್.
In several of the matter cities,
36/23 I filed.
it is shown, it is seen that the concerned case worker who is putting the note is not clearly legible and the handwriting not at all readable. Hence, it is directed to the registry that any such note to be put up by a case worker who has put the note here shall not be in manuscript, which will be in typed version only.
It is directed to the registry that
Muncheri.
in several of the matters, it is seen that the concerned case worker who is putting the note is not clearly legible and the handwriting is not at all readable. Hence, it is readable.
One sentence says not at all readable. Several oral directions given to the registry to ensure that put up by him is readable, is note put up by him would be readable, has not yielded any. That has not shown any progress. I mean, hence. Hold on. The other reason I am not extending the interim order. One, you caused enormous delay in taking the process. Second, made a submission that you do not remember, your colleague has lost the file, everything. Yes. Next.
Number 44, B. Pramod. Murthy K.
I expect the honesty from the councils. Yes. Next.
Cell number 44,
No. Absolutely not.
B. Pramod.
Absolutely not. ಪಾರ್ಟಿಗಸ್ ಕಳ್ಕೊಳ್ಳಿರೋ ಕೋರ್ಟ್ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಹೆಚ್ಚಿನ ವಿಧೇಯತೆ ತೋರಿಸ್ಬೇಕು. ಕೋರ್ಟ್ನ ಅಸಡ್ಡೆ ಮಾಡಬಾರ್ದು. ನೋ. You are wasting the time of the court. Next matter, please. Model, action model.
B Pramod, till number 44.
Sir, B for the appellants.
The register of judicial report
Last occasion, my lord.
and overruled the office objection regarding arraying of the respondent time. The flagship previous office objection system.
Yes. Then other media. Very straight. Yes,
We request my lords to kindly see page number 4, my lords, 4 and 5.
What for?
Looks added different number 5, my lords, at page 4. But the final download R3 and the central pension accounting officer. Next page will different number 5, my lords, as a respond number 3, page 4 and 5. Lords, on the earlier occasion at
What is the note beneath the cost title?
What had happened was last time, when I filed the appeal, by mistake, I had mentioned that defendant number 1, my lords, and other 2, they had been deleted. And in respect of defendant 5 also, I had made a note, my lords, I am not erring as a party. My lords had perused on the last occasion, said that the order is even against him, the direction is.
That is true. Say you were the wrong noting, let the court to make observation, right?
Sorry, my lords, I can't change the note because earlier I had filed it. My lord's permit, I will change, my lords. Because last occasion, my lords observed that I have not erred as defendant number 5 as a party. My lords were pleased to see the order and say that the implementation has to be done by them also. So they may be erred as party. Error madidini. A note I can't change, my lords, without permission.
ಅದನ್ನೇ ಹೇಳ್ತಿರೋದು ನೀವು ಒಂದೇ sentence ಹೇಳಿ. I shouldn't have made that note. I have made that note which caused so much of inconvenience to the court and the registry ಅಂದ್ರೆ ಮುಗೀತಿತ್ತು. ಅದನ್ನ ಬಿಟ್ಟು ಉಳಿದಿದ್ದು ಎಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀರಿ, ಬಹಳ ಪ್ರಾಮಾಣಿಕ ಅಂತ ತೋರಿಸ್ತಿದ್ದೀರಿ. ಯಾಕೆ?
ಅಲ್ಲ, ಮೊದಲು ನಾನು ತಪ್ಪಾಗಿತ್ತು
ಅದನ್ನ ಹೇಳ್ಬಿಟ್ರೆ ಸಾಕಲ್ಲ, ಅದು ಬರಲ್ಲ, ಆ ಶಬ್ದ ಬರಲ್ಲ ಬಾಯಿಂದ. ಮೂವತ್ತೈದು ವರ್ಷದಿಂದ ನೋಡ್ತಿದ್ದೇನ್ರಿ, ಬೇರೆದೇನಿಲ್ಲ. ಸಿನ್ಸಿಯಾರಿಟಿ, ಆನೆಸ್ಟಿ, ಮುಗಿದು ಹೋಯ್ತು ಕತೆ. ಬೇರೆ ಏನೂ ಬಯಸಲ್ಲ ಕೋರ್ಟು. ಅದನ್ನ ಬಿಟ್ಟು ಉಳಿದಿದ್ದು ಎಲ್ಲ ಮಾಡಿರೋ ಮಿಸ್ಟೇಕ್ಗಳಿಗೆ ಎಕ್ಸ್ಕ್ಯೂಸ್ ಹುಡ್ಕೋದ್ರಲ್ಲಿ, ಸುತ್ತಿ ಬಳಸಿ ಬೇರೆದೇನೋ ಹೇಳೋದ್ರಲ್ಲಿಯೇ ಎಲ್ಲರೂ ಸಮಯ ಕಳಿತೀರಿ. ಅದನ್ನೇ ಅಡ್ವೊಕೇಸಿ ಏನ್ ಕಳ್ತೀರಿ ಹೊರತು ಇಲ್ಲ. ಎಷ್ಟು ಜನ ಬರ್ತಾರೆ ಅಡ್ವೊಕೇಟ್ಗಳು, ಫೇರ್ ಆಗಿ ಹೇಳ್ತಾರೆ, ಸ್ವಾಮಿ ನಾನು ಓದ್ಲಿಲ್ಲ. Even I have entertained the submission of a learned, one of the senior most counsel. ಬಂದು ಫೇರ್ ಆಗಿ ಹೇಳಿ, ಸ್ವಾಮಿ ನನ್ನ ಮೊಮ್ಮಗು ಜೊತೆ ಮಧ್ಯಾಹ್ನ ಲೂಡೋ ಆಡ್ಬೇಕು, ನಾನು ಪ್ರಾಮಿಸ್ ಮಾಡಿ ಬಿಟ್ಟಿದ್ದೀನಿ ಮೊಮ್ಮಗನಿಗೆ ಮಧ್ಯಾಹ್ನ ಬಂದು ಲೂಡೋ ಆಡ್ತೀನಿ ಅಂತಪ್ಪ, ಹಾಗಾಗಿ ಮ್ಯಾಟರ್ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ನೀವು ಮುಂದಿನ ವಾರ ಹಾಕಿ ಹೋಗ್ತೇನೆ, ಖುಷಿಯಿಂದ ಕೊಟ್ಟೆ ಟೈಮ್. ಕೇವಲ ಬೇಕಾಗಿರೋದು ಆನೆಸ್ಟಿ.
It's my mistake.
Counsel for the appellant who is physically present submits that though he had arraigned defendant number 5 as respondent number 3 in this appeal, however, by oversight he has put a note below the cost title in the appeal that the defendant number 5 has not been arraigned as a party in this appeal. In view of the same, registry to verify and proceed. Yes.
Hearing on integrated application, section 45, DP, S.A. Sami.
Hearing.
Counsel for the appellant who is physically present. Once again, praise for time. A perusal of the order sheet will go to show that in this appeal of the year 2017, the appellant has filed IA 1/22 under section 151 CPC for expedite hearing of this appeal. This IA was shown to have been filed on 15/6/2022. However, thereafter, the appellant has not even interest in proceeding with the said IA. When the matter was taken up on 14/6/2023, the learned counsel for the applicant of the appellant had remained absent. Today, even though he is present, he is praying for time. As such, when the appellant himself is not interested in proceeding further in the matter, the IA 1/2022 loses its meaning. As such, IA 1/2022 stands dismissed. The matter stands adjourned.
Bill number 46, Subbareddy KN, SG Hegde for respondent.
I appear for respondent in this case, my lord.
Both of you have got anything to add more than what you have stated respectively in your IA and objection?
Respect to the condemnation of William Millards, I have stated that.
What you have stated, I have read. Have you got anything more to say in addition to that? You have got anything more to say in addition to objection?
Yes, Swami, I have stated whatever that to be stated in my statement of objection.
If you could able to transfer an amount of rupees 5,000 as cost to the account of the learned counsel for the respondent, delay would be condoned. If you want a day's accommodation, 500 rupees extra every day, maximum 7 days.
Cost may be reduced. Cost may be reduced.
I can increase if you feel like.
I'll go down.
Call this matter after 5 minutes. In the meantime, secure his number and transfer rupees 5,000 towards the cost to show me the acknowledgement.
Number 47, Prasad B. Suyog Herle, correspondent.
Appear for the respondent. Today's to file objection.
Counsel for the appellant not present. Counsel for the respondent. All present. Hence the matter could not be proceeded.
Number 49, Sharat S. Gowda. Vijay Kumar for Kevata, respondent 1.
Application seeking direction to the jurisdiction police to implement the path of the court. Peaceful person and enjoyment of my property. That application, my learned friend has filed an objection to that application. Maybe I
Learned counsel from both sides present. As requested for by learned counsel for the appellant, 4 weeks time is granted to file paper. Yes.
Serial number 50, H.V. Devaraju.
Counsel for the appellant alone present and appear for respondents. Finally, 10 days time is granted to respondents to file their objection if any to pending evidence.
Serial number 51, H.R. Santosh Sagar T. Nahar, correspondent.
My lord, I appear for the respondent.
Whom you appear for?
Lord, the respondent. I seek for permission to file objections, Your Honor.
The counsel for the appellant is physically present. The counsel for the respondent is appearing through video conference and tries for a short accommodation to file his objections to IAS. 2 weeks time is granted. Yes.
If I may submit, my lords, the matter before the executing court is listed on 10th of this month.
ಸಂತೋಷ ಅವತ್ತಿನ ದಿವಸ ಆರ್ಡರ್ ಮಾಡ್ಲಿ ಅವರು ಮಾಡ್ತಾರೆ.
My RFA will become infectious.
Since the appellant who had filed has filed this RFA belatedly with a delay of 835 days, and also did not insist for an interim order at the earliest opportunity, despite knowing that the decree holder had filed an execution petition against him as long back as in the year 2020, I do not find any urgency in considering the application for interim order. Yes.
Case number 52, Ganpati Subhai Bhatt.
It appears there is some objection with respect to the IAS.
So I have completed all the objection right by office.
Call with respect to LRs of deceased appellant number 4
That is also right.
to be filed ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
File ಮಾಡಿ. Recent appellant. ಅದು enclose ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ ಇದು ಮಾಡಿ.
They have kept that office objection open. Learned counsel for the appellant present and submits them. He has already filed the wakalat for the legal representatives of deceased appellant number 4 in the registry. However, the registry in its endorsement dated 26/6/2023 has still shown that such a wakalat is not filed. Hence, registry to verify and proceed further. Yes.
Serial number 53. Hartala Kotwal.
Now, parents are matter good enough.
Number 54.
Pass over the past twice.
Then it's senior counsel is honest.
A junior counsel for the appellant prays for the pass over. Learned counsel for the respondent present. Matter is passed over.
Pass over matter. Serial number 46. Subbareddy KL. 46.
Before admission ಅಂದೆ ನೀವು ಇಲ್ಲೇ ಎಲ್ಲದೂ ಹೀಗೆ ಮಾಡ್ತಿದ್ದೀರಿ ಒಂದು ಮ್ಯಾಚ್
Serial number 55. Continuation of this. Serial number 55.
Appellant is now filed.
ನಿದ್ದೆ ಮಾಡ್ತಾ ಕೂರ್ತಾರೆ ಇನ್ನೊಬ್ರು ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ತಾ ಇರ್ತಾರೆ ನಾನು ಹೇಗೆ ಕೆಲಸ ಮಾಡಬೇಕು.
He was not a party to the suit. Seeking
At the submission of learned counsel for the appellant, issue notice to the respondents both on the main appeal and on pending IAs. Please, yeah. Yes.
Passed over matter. Serial number 46. Subbareddy KL.
ಓದಿದ್ರೆ ಕರಿಬೇಡಿ. ನೀವು ಮಾಡೋ ಮಿಸ್ಟೇಕ್ಗಳು ನನ್ನ ಎಂಬ್ರಾಸ್ಮೆಂಟ್ ತಳ್ಳುತ್ತೆ.
Serial number 46. Subbareddy KL.
None appear. Hence the matter stands subject. Yes.
Admission matters. Serial number 56.
other side.
The counsel from both sides present and submits the settlement process is going on and there is likelihood of matter being settled. With this, they pray for 2 weeks accommodation. The time as spread is granted.
Number 59, Ramesha MS.
That is a matter could not be proceeded to.
Number 60, Venkatamana case.
Same order.
Number 61.
I appear for the appellant, my lord. I am appealing for the appellant, my lord.
Notice, TCR. Yes.
Serial number
So,
62.
notice to 2 to 7 may be dispensed with, my lord, because my.
ಅದಕ್ಕೊಂದು ಮೆಮೊ ಹಾಕಿ ಮಾಡುವ.
Yes, my lord. Yes.
Serial number 62. Ramurthy.
This case also, my lord.
Same order, notice, TCR. Yes.
Serial number 63. Subhash Chandra Bose.
Also, I will file a memo.
Yeah, file a memo, we will consider.
Yes.
Serial number 63. Subhash Chandra Bose.
Here for the appellant, my lord.
Yes.
My lordship, this was a suit filed by the respondent, my lord, for seeking a relief of refund of the amount which was said to have been given under the agreement of sale, that is Exhibit A P1, my lordship. It was entered into with the appellant hearing and also with her brother who is no more, my lord, who was died, my lord. My lord, he sought the refund of the amount basing on the citing the invalid reason that in the said house, appellant's brother, namely Ravi, was committed suicide. My, this appellant, my lord, who lost his father and also lost her brother, has ever been ready and willing to perform or part of the contract under the agreement to sell, my lord. Forever, my lordship. Still, only on the reason that her brother was also a party to the agreement of sale, committed suicide in that house, he sought for the refund of the amount, my lordship. Now she is totally unable to pay back the amount, my lordship. She has no source at all. Now she is ready and willing to perform her part of contract, my lordship, under the Exhibit P1 agreement of sale, my lordship. However, without considering the her willingness and readiness, my lordship, trial court passed an order against passed a judgment and decreed the suit, directing the appellant hearing to refund the amount of rupees 11,000, my lordship, with the interest at the rate of 6%, my lordship.
For the submission of land council for the appellant, there is the
Kindly,
notice, TCR.
kindly.
Yes.
64. C.R. Subramania, Giridhar SP for respondent.
Parents, the matter could not be proceeded.
Serial number 65, Vishwanath Shetty.
Next. Number 9 and 10. Respondent number 1 is right. The respondents concerned with our government officers, they are also daily and claim over this future. The respondents, I refer as plaintiff. The plaintiff claims that he himself and his mother have jointly purchased the land clearing survey number 65/1. Now they wanted to claim as it is a renumbered or new number is assigned as 64/1. And this property was measuring 6 guntas of land according to them. And they contends that their sale deed was dated 28/2/1961, my lords, which is being purchased from Sinappa and others. They further contends that, my lords, they are in possession of this property. Revenue authorities have entered their name pertains to survey number 64/1 of Madiwala. They are in possession. But my specific case is that, my lords, please, survey number 64/1. I purchased in pursuance of an agreement of sale dated 27/1/1994 from Sinappa and his family members. I have filed a suit for specific performance of the agreement of sale on in OS number 6654 of 1995. Under the agreement of sale, since the position was delivered to me, not from the government of sales, my lord, in the year 2004, during pendency of the suit itself, an obstruction was there to put up construction of a police station, my lord. I filed a suit in OS number. I filed the suit in OS number 3566, my lord, of 2004. My lord, in my suit, the very plaintiff in the suit before the trial court in this matter has also included. My suit was taken up consideration on all merits against the government and also this Shamana. However, since my suit was for bare injunction against the government, my suit is declared by God. It is held that I am in a position, my agreement of sale, the decree passed in my favor.
Take steps, let notice, emergent notice.
There are, my humble submission. In this suit is decreed in their favor. My suit is decreed by favor. Now, in this suit, a portion of the property is acquired by BMR sale authority for compensation award. Alli tagondi idನ್ನು ಉಪಯೋಗಿಸ್ತಾರೆ ನನ್ನ injunction decree ನಲ್ಲಿ stay ಆಗಿದೆ ಸ್ವಾಮಿ. ಇಲ್ಲಿ another 2 appeals are government ಮತ್ತೆ ಇವರು ಹಾಕಿರೋದ್ರಲ್ಲಿ ನಂದ್ರಲ್ಲಿ stay ಮಾಡಿರೋದ್ರಿಂದ ಇದನ್ನು ಉಪಯೋಗಿಸ್ಕೊಂಡು amount ತಗೊಳ್ಳಿಕ್ಕೆ ಪ್ರಯತ್ನ ಅಷ್ಟೇ some problem. Suppose if
whether connected RFAs are there?
Please, madam.
Whether any connected RFAs are there?
There, I am referring to that. RFA number 6.
Counsel for the appellant submits that respect to the same subject matter property, RFA number so and so and RFA number so and so also
there is
pending before this court. She list them together. Yes.
Stay is not granted, my lord. Amount will be.
ಆಗಲ್ಲ.
Seal number 66, Narasimharaju.
Bacha.
The suit for injunction. Appellant has filed for the trial court. Two sites. Site number 49 and site number 50. Site number 49 not she acquired by virtue of register sale dated 12/11/1992 as per exhibit P1. Site number 50, she is acquired through a will which executed by her brother dated 13/9/2004. That Kata was affected in both the sites. She is paying tax to the concerned authority. As on today, she is in possession of the property. By virtue of the will, as per exhibit P31, the BBMP conducted a spot inspection.
1 second, please. 1 second.
Please.
Yes, please.
My site is concerned. But the other side is concerned. I acquired the will. The airport station, nobody has disputed. Even defendant also has expertise.
Yes.
But as per exhibit will, the second site is concerned. I acquired the will.
How did you acquire the first site?
First site by virtue of the registered sale.
Yes. Second site.
Second site, my brother.
Second site is an item number 2.
Please, item number 2. My brother acquired by virtue of the registered sale. As per exhibit.
Who had taken under registered sale deed?
My brother.
Your brother.
My brother. Subsequently, Lord, he bequeathed the will. He is a bachelor, Lord. He is not married. He bequeathed will on 13/9/2004. He died. Subsequently, Lord, on spot inspection verification of the document, the BBMP affected Kata in my favor. And I am paying up to tax as on today. Both the sites are not adjacent to each other. I am in possession of the property, both the sites. But defendant, these are the site number 49 and 50, right, for 1 and 2. Defendant has created 49 bar A, 49 50 bar A. He has created some documents and he tried to interfere with our portion of the property, which is not all in existence. Already there was a decree with regard to that. Towards southern side, there is a road.
But I approach the trial court on the ground that I am in possession of both the properties. One is acquired through a bill, another one is acquired by a registered bill. The trial court will not defeat the suit in respect to item number 1 is concerned. With regard to item number 2 is concerned, the trial court hold that a bill has not been. Nobody has disputed the bill. Even defendant also was placed expert. It is a registered bill and no family members are available. He is my brother. Trial court says, no, you have not proved the will. And the signature has also not been examined. Section 65, 67 have not been complied. This is the finding not issued by the trial.
For the submission of land council for the apparent, there is the memorandum of appeal into judgment and IA 1/2023. Contention of the appellant is that even though the appellant has been in the lawful possession and enjoyment of the social property item number 2, and her title over the property based upon the will has not been denied by the defendant who had placed ex parte still. Court has not decreed her suit with respect to item number 2. That counsel further submits that because of the non-decreeing the suit with respect to item number 2, the appellant is facing the interference by the respondent. Next line. In the light of the above, both parties are directed to maintain status quo as on today with respect to social property item number 2 for a period of 8 weeks from today. Issue emergent notice to the respondent both on the main appeal and on IA 1/23. Appellant to pay the necessary process and furnish copies in the registry if not already done within a day from today.
Number 67, Kavita Damodaran.
PCR.
Defendants of the
Submission, my lord. Yesterday around 12 o'clock, they served the appeal memo copy, my lord. So I filed IA number 2/23. In the said IA number 2/23, I sought for the temporary injunction, my lord. So requesting this honorable court restrain the appellants and respondent number 5. After serving the copy of the appeal memo, I came to know that the respondent 5 is arrayed as respondent number, appellant number 2. Then only I came to know that today I am filing a memo and withdrawing IN number 2/23 and I am filing a fresh out of 13 application, my lord. Before that, my lord, there was an order of status quo. Your lordship will kindly come to page number 33.
You are a caveator.
I am a caveator.
You have any objection to be filed to IA 1/23?
Yes, sir. I have an objection.
Then you should make that submission first.
I have an objection. I may be granted a week's time, my lord.
You are not pressing IA 2/23. File the memo.
I am filing memo. I started the copy on.
Let her file objection to your IA.
Yes.
Caveator, she is complaining that it's only yesterday evening the copy was served upon her. The learned senior counsel for the appellant and learned counsel for caveator are physically present. Learned counsel for the filed a memo not pressing 2/23, stating that there is some misdescription of the rank of the parties. In view of the memo on supporting submission, the said IA stands disposed of as not first. Next line. Learned counsel for the caveator further submits that the copy of memorandum of appeal with the IA was served to her only yesterday evening, as such she requires some time to file objection to IA 1/23. View of the matter, a week's time is granted to file objection if you need to the said IA.
Number 68, DS Postman.
Next Thursday.
1 week ಅಂದ್ರೆ ಬರ್ತದೆ 1 week.
13th ನಂಗೆ ಒಂದು ಟ್ರಯಲ್ ಇದೆ ತುಮಕೂರು ಕೋರ್ಟ್ ಅಲ್ಲಿ 12th ಆಗ್ಬೋದು
17th ಆಗಬಹುದೇ? List the matter. 12th board ಬಹಳ ಹೆವಿ ಇದೆ, I do not know.
14th.
List the matter on 14th.
Yes.
That's good. 14/7. Yes.
Seal number 68, DS Osman.
Please, pardon, my lord. Friday ಹಾಕೊಳ್ಳಿ ಅಲ್ಲಿಗೆ ಬರ್ತೀನಿ, ಅಲ್ಲಿಗೆ ಬಾ ಅಂತ ಹೇಳಿರ್ತಾವು. ಅಲ್ಲಿ Friday ಬರ್ತೀನಿ. I am not well, that's why I couldn't come.
Place for time, hence the matter stands adjourned. ನಿಮಗೆ ಯಾವತ್ತು ಅನುಕೂಲ ಆಗ್ತದೆ ಒಂದು ಮೆಮೊ ಮೂವ್ ಮಾಡಿ ಲಿಸ್ಟಿಂಗಿಗೆ ಹಾಕುವ, ಬನ್ನಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. Matter stands adjourned now.
ಸೋಮವಾರ ಅಂದ್ಬಿಡಿ, ಬಂದ್ಬಿಡ್ತೀನಿ ಅವತ್ತು. ಸೋಮವಾರ
17th ಮಂಡೇ ಹಾಕೊಳ್ಳೋಣವೇ?
ಆಗ್ಬೋದು.
The matter on 17. 7 as yes. 17/7 Monday.
Please, I am sorry, my lord, for the
Further ತೊಂದರೆ ಇಲ್ಲ. Yes.
Further arguments, seal number 69, Sudhindra PE, Shant Kumar, SP.
Counsel for the appellant not present, learned counsel for the respondent alone present. Matter is passed over. Madhyana.
70, R.V. Jayaprakash.
None of them passed over. '71. Yes. None of them pass over.
Seal number 73, N.V. Manjunath, Shanmukappa,
Okay, also.
Bill number 74,
None appears the matter could not.
For
be
the
proceeded.
respondent in this case, my lord. Respondents
Another-
number 1 and 2.
Also for respondent number 1 and 2 alone is appearing through video conference. Hence the matter could not be proceeded with. Adjourned. Yes.
Kindly.
Bill number 75,
Afternoon, my lord. Thank you.
Yes, please.
Sukumaran G,
There is a
Yes, please.
the club related matters from 2017 taking advantage of the interim order. They're not allowing the respondents to utilize the club. It's almost 5 years now, 6 years. Last time
ಅವ್ರು ಬಂದಿಲ್ಲ ನಮಗೆ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ವೆಕೇಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಬರ್ತಾರೆ
ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ. IA2 is pending.
ಮತ್ತೆ ಅದನ್ನ ತೋರಿಸಿಲ್ವಲ್ಲ ರಿಜಿಸ್ಟ್ರಿ ಅವರು
Is
ಅದನ್ನ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ ಅವಾಗ ಬರ್ತಾರೆ ಅವರು ಇಲ್ಲ ಹೋದ್ರೆ ಹಾಗೆ ಕ್ಲಬ್ ನಲ್ಲಿ ಬಂದು ಎಲ್ಲ ಫೆಸಿಲಿಟೀಸ್ ಎಂಜಾಯ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾರೆ.
A date may be fixed, my lord, kindly.
Get it listed whenever you want. Yes.
Bill number 75, Sukumaran G, K. Nandish Babu,
Oh, sorry, my lord. It was 75. I have to appear.
74 ಅಲ್ಲಿ ನಾನು ಪ್ರೆಸೆನ್ಸ್ ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 17/7 ಅಂತ ಮಾಡಿ 17/7 ನಿಮ್ಮದು.
Much obliged.
That no further adjournment would be granted in this appeal of the year 2017. Yes.
Bill number 75, G. Sukumaran,
My lord, I made a submission instead of it was 75. I was supposed to appear, not 74. G. Sukumaran was appellant and Nandish Babu for respondent. I'm really sorry, my lord.
Yes, 74 ಅಲ್ಲಿ ನನ್ನ ಅಪ್ಲಿಕೆಂಟ್ಸ್ ಅರ್ಜೆಂಟ್ ಅಷ್ಟೇ ಮಾಡಿ ಬಿಟ್ಬೇಡ ಅಂದ್ರು. Yes, of course.
Bill number 75, Sukumaran G, K. Nandish Babu,
It's the matter in the next week.
76, MJ Alva, C.K. Nandakumar, for Kevata respondent.
Thank you, Lord. This is for 1 week.
Last week ತಗೊಂಡಿದ್ರಿ time.
Other side.
Sixty-six, 2023. At the request of learned counsel for the appellant who is physically present in the court, as finally a week's time is granted.
Sorry, my lord. It is incorrect, my lord, because they had informed us subsequently that they have taken time.
Then probably when
Maybe-
taking time, they might
maybe-
have submitted
maybe
that
some-
they appear for the appellant.
Maybe some wrong submission might have been made. They informed us subsequently.
The request of the learned counsel for the appellant. 10 days time as spread is granted.
Serial number 77, Ken Purushothaman.
ಯಾಕ್ರಿ?
My senior developed retina detachment is unwell. Developed retina detachment, his eyes. Therefore, it's time.
It's not cataract. It is a problem with retina.
Retina detachment.
Oh. Is required to undergo any surgery or laser treatment would do.
Underwent 2 surgeries. One eye is partial.
Now, if there are holes in the retina, to some extent, they can be managed through laser treatment. If it is a detachment, it is a bit difficult.
Underwent 2 surgeries and currently under Ayurvedic because one eye is partially blind.
And counsels, learned junior counsel for the appellant and learned junior counsels for both the parties are physically present and pray for a short accommodation. 2 weeks time as finally.
officer.
Court officer. Hello. Hello. Court officer. Court officer. Court officer. Court officer.
ಸರ್ ಸಾಹೇಬ್ರು ಬರ್ತಾ ಇದ್ದಾರೆ ಒಂದು ನಿಮಿಷ. So, madam, seal number 9, Sri Pradeep C. Bhatt, MT Rangswamy.
It's good. That's good. Called again in the afternoon, the head counsel for the appellant who is physically present files a memo seeking withdrawal of this appeal as the appellant is not interested to proceed in the appeal. In view of the memo supporting submission, the appeal stands dismissed as not trust. Yes.
Serial number 54. Samit S. MB Chandrachud.
Yes, please.
Accepting.
Yes.
Moving for permanent injunction in respect of a site measuring 16 to 40. Situated in Mallathalli village, Yeshwanthpura village. The land came to be acquired for Ruipuram House Building Society.
How many IAs are pending now in this matter?
IA is for stay, another is for vacating.
Vacating stay. How IA for vacating stay is surviving? Yes. Have you filed your objection to IA 1/23 for stay?
Yes.
You have filed.
Yes.
Called again, learned counsels from both sides. The learned senior counsel for the learned counsel for the appellant and learned counsel for K-waiter are physically present. Counsel for the K-waiter submits that in view of the non-extension of the interim order granted earlier in this matter, comma, on the previous date of hearing, IA 2/2023 may not survive. Next slide. In view of the fact that there is no extension of interim order on 14/6/2023, as such, there is no interim order in operation as on date. IA 2/2023 does not survive. Accordingly, the said IA stands disposed of. Yes. Now pending IA is IA 1/23. The objection could be. No, you are suffering interim order of injunction. Injunction simpliciter.
The tendency of the suit also, there is an order status.
How IA under Order 41 Rule 5 is maintainable? No, it is not stay which can be equated to Order 39 Rule 1 and 2. There is no executable order. Probably this IA is not maintainable.
Injunction order is there. Suit is for permanent injunction.
Yes, that's not executable.
It also can be executed. Injunction order is disavowed. Can go for.
That is content.
No, they can go for attachment also.
You want to continue with this IA or want to file another appropriate IA with the relevant provision of law? You file separate IA. The senior counsel for the appellant submits that.
Let this IA be there, we'll file one more separate IA. Or my letter friend says.
Counsel for the senior counsel for the appellant on instructions. Place for a short accommodation, hence the matter stands subject. Okay.
Other argument, serial number 69, Sri Sridhar B, Sri Shant Kumar SP.
Yes, please. ಬೆಳಗ್ಗೆ ಅವರಿದ್ರು ನೀವಿಲ್ಲ, ಈಗ ನೀವಿದ್ರಿ ಅವರಿಲ್ಲ. Yes.
Stop it. There are 10 of the judgment. A first. Turning page 21 and page 9 of the judgment. Thus, the terms of the document cannot be disproved by oral evidence. However, the proviso 1 of section 92 of the Evidence Act permits to prove any intimidation or want of due execution of parole evidence. It also permits to prove a fact which would invalidate such document. Therefore, whether the evidence adduced is sufficient or either invalidate the exhibit B2 or to prove want of due execution has to be considered. Even otherwise, what is in the nature of evidence adduced by the defendants and how the defendants want to refute the claim of the plaintiff with reference to exhibit B2 has to be considered for making a wholesome consideration of the entire dispute. The learned counsel for the defendant has brought to the notice of the court to the recital of the chief examination affidavit of PW1, which are as follows. The said sale negotiation had taken place in the presence of the witness. The defendants received an advance sale consideration of 14 lakhs per month on the same day before the witnesses and executed registered sale agreement in my favor. Since the defendant has to search for the rented house to vacate and deliver the vacant position of the suit house, the defendants gave instructions to document Registry Srinivas Babu to prepare the said sale agreement. The defendants' two daughters also put the signature to the said sale agreement. Thus, it is argued that the evidence of PW1 deposed that negotiation have taken place in the presence of the witness. On the same day, the registered sale agreement was executed in favor of the plaintiff. The defendant had to search the rented house to vacate and deliver vacant position. The defendants gave instruction to the document writer Srinivas Babu to prepare the sale agreement, and the daughters of the defendants have also put their signature to the agreement. The above four circumstances are sought to be contradicted through the cross-examination version of PW1, which is as follows. Thus, it is vehemently argued by the learned counsel for the defendants that there is variance between the chief examination version and the cross-examination version regarding the date of payment of consideration, 14 lakhs, and the presence of witness at the time of negotiation. It is therefore argued that according to PW1 as stated by him in the cross-examination, at the time of sale, talks none else but the defendants and the plaintiff are present, and he has paid 5 lakhs on the very same day and paid 9 lakhs on the next day, which is not mentioned by PW1 in the examination chief. Therefore, it is argued that the very transaction alleged by PW1 is doubtful and PW1 has suppressed the true facts. Per contra, the learned counsel for the plaintiffs has vehemently argued that the said variance is not a material variance and that in fact supports the reality which is forthcoming from exhibit P2. It is argued by him that the date of agreement is 3/12/2014, whereas it is registered on the next day, 4/12/2014, and therefore payment of consideration of ₹5 lakhs on 3/12/2014 and payment of another part consideration on 9 lakhs at the time of registration is not unnatural in a transaction related to your property. No doubt, it is true. It is mentioned in the chief examination that on the same day PW1 has paid 14 lakhs to the defendants and the defendants executed
registered sale agreement in favor of the plaintiff. However, that statement, if it is strictly construed as argued by the learned counsel for the defendants, the document should have been executed and registered on 3/12/2014. But the document is not registered on 3/12/2014, but in fact it is in fact registered on next day, that is 4/12/2014. Therefore, too strict interpretation of the date of payment mentioned in chief examination may not be proper under the circumstances of the case. Even going by the cross-examination version of P11, that the advance consideration amount is paid in 2 installments on 2 days, then also the total consideration amount paid would come to 14 lakhs, which is the examination in chief version of PW1. In other words, to be precise, there is no variance in the total consideration amount paid in the examination in chief and in the cross-examination version of PW1. Insofar as the presence of witness and the daughters of the defendants at the time of sale talks, it is relevant to note that the agreement of sale is not a compulsorily attestable document requiring presence of attesting witnesses. For due execution of such a document, therefore, even if it is considered that no attesting witnesses were present at the time of sale talks, it would not by itself invalidate the transaction. If that version of PW1 is considered only to harp upon his veracity, it is relevant to note that PW1 is deposing in the cross-examination regarding payment of advance consideration of Rs 5 lakhs and holding sale talks prior thereto is with reference to the day before the execution of the agreement of sale for sale. That is clear from the evidence of PW1 found at page 7 at line 2 of cross-examination. He has clearly deposed that the agreement was executed on the next day of payment of Rs 5 lakhs as advance consideration. Thus, the absence of witness is pertaining to the day before the execution of the agreement, that is 3/12/2014. Therefore, such a variance regarding the presence of the witness is not much material to tarnish the veracity of PW1. The occurrence of events need not be proved, pleaded and proved with mathematical certainty. The substance of material fact is sufficient to be pleaded and proved. In the evidence of P21, there is no variance in the substance of the statement is relevant. It is relevant to note that 2 witnesses to exhibit P2 are the daughters of the defendants. The third witness to the said document is one Manjunatha, who examined as PW3. PW3 has deposed that he has gone to the office of the sub-registrar at the time of registration of exhibit P2. However, the person who was signed as witnesses to the document before the sub-registrar concerned are one Nagaraj and a very scribe Srinivasa Babu. Thus, the actual transaction has taken place prior to the registration of exhibit P2, but not directly at the time of registration of exhibit P2. Therefore, paying advance consideration in 2 installments as deposed in the cross-examination cannot be considered as suspicious circumstances to invalidate exhibit P2. As per Indian Contract Act, as per section 25, a past consideration is also a valid consideration. Therefore, merely because PW1 has deposed that he has already paid Rs 5 lakhs on the previous day and paid another 9 lakhs on the day of registration of PW2, it cannot be held to be bad for want of consideration or any other counts on account of such statements of PW1. When the defendants have specifically reported the receipt of the consideration of Rs 14 lakhs as advance consideration in exhibit P2, any amount of oral evidence to vary from the terms of exhibit P2 by way of parole evidence would be inadmissible. In fact, the quantum of consideration has nothing to do with the due execution of the document in the given exceptions to the general rule contained in section 92. In the cross-examination, PW1 has deposed as follows. It is vehemently argued by the learned counsel for the defendant that the plaintiff as having an income of Rs 250 per day cannot pay huge consideration of 14 lakhs and that PW1 is not deposing the truth and he is a money lender. It is not the defense of the defendants that the plaintiff has no capacity to pay the balance consideration, sale consideration, and hence the quantum of present income of plaintiff is immaterial. Even if it is considered the plaintiff has present income of Rs 250 per day, it does not reflect upon the money possessed by him and his capacity to pay consideration amount. merely because PW1 has deposed as such, he cannot be termed as a fully unreliable witness by terming himself as a person uttering complete falsehood. In the decision reported in so and so, it is held as follows. The maxim fallis in fallis in omnibus has no application in India, and the witnesses cannot be branded as liars. The maxim fallis in fallacies is in omnibus has not received general acceptance, nor has the maxim come to occupy the status of rule of law. It is merely a rule of caution. All that it amounts to is that in such cases, testimony may be disregarded, and not that it must be disregarded. The doctrine merely involves a question of weight of evidence, which a court may apply in a given set of circumstances, but it is not what may be called as a mandatory rule of evidence. From the above, it is clear that merely because a statement made by the witness is inconsistent with an aspect which is not relevant or not much in dispute in the proceedings, cannot be relied upon to discredit the witness on material aspects. Hence, PW1 cannot be branded as a person uttering falsehood merely for his above statement. Hence, the argument of the learned counsel for the defendant in this regard acceptable under law. The learned counsel for the defendant has also relied upon the statement of PW1 made in the cross-examination, wherein it is deposed as follows. PW2 has deposed that he knows the plaintiff and he writes several documents for the plaintiff, and the plaintiff is an agriculturist. PW2 has expressed ignorance regarding the suggestion put to him that the plaintiff does money lending business. It is argued that the very fact that PW2 writes several documents for plaintiff goes to show that PW1 is a money lender. It is also argued that the very fact that PW2 expressed his ignorance but not denied this aspect clarifies the truthfulness in the suggestion that PW1 does money lending business. However, it is relevant to note that PW2 is not a party to the suit but only a witness. What are the documents which are previously written by him for the plaintiff is unclear in the statement of PW2. With whom those transactions are made, what happened subsequent to those transactions, whether they are complete contracts or executory contracts, etc., are unclear in the above statement of PW2. Therefore, merely because of this above statement of PW2, the plaintiff cannot be termed as money lender, as argued by the learned counsel for the defendants. It requires more cogent evidence, both oral and documented. Doing money lending business without license would amount to an offence prescribed by statute. Hence, superficial statements cannot be used to draw surmises and conjectures about a thing which is not directly deposed. None of the persons who have done such money lending transactions with PW1 have come to the court to establish the alleged money lending business of plaintiff. Even if it is considered for the sake of argument the plaintiff is a money lender, there is no prohibition for such a person to purchase a property by entering into an agreement for sale. Therefore, whether the present transaction is a money lending transaction has to be established by defendants with cogent evidence. Much need not be discussed about the said money lending business, for the evidence placed on record grossly falls short of the requirement of proof of such business alleged to be run by the plaintiff. PW2 has deposed nothing as to the terms of Exhibit P2 as money transaction. He has throughout maintained that it is a sale transaction, is relevant. PW3 is a witness to PW2 sale agreement. He has not signed before the sub-registrar as a witness to the document. It is also relevant. However, he himself has deposed that he has gone to the sub-registrar's office and he has witnessed the transaction between the plaintiff and the defendants. PW3 was secured for issuing and summary, but PW3 did not file his examination, chief examination affidavit. Rather, he directly came to the witness box to give evidence pursuant to the summons. After initial questioning, the learned counsel for the plaintiff has prayed for permission to cross-examine the witness by treating him as hostile. After permission, the cross-examination was granted. After permission, the cross-examination was granted. He has cross-examined PW3. Thereafter, learned counsel for the defendant has cross-examined PW3. In the said cross-examination, PW3 has made allegations against the plaintiff that the plaintiff does money lending business. He has several houses, land, and sites. In this regard, PW3 further cross-examined by the learned counsel for the plaintiff. It was objected to by the learned counsel for the defendant that further cross-examination of PW3 cannot be permitted after defendant's cross-examination. However, such an argument was held to be not sustainable, having regard to the fact that PW3 did not fully support the plaintiff, but was cross-examined as if he is a hostile witness, hostile to the interest of the plaintiff, and hence such a further cross-examination directed against new aspect deposed by the witness is called cross-examination made by defendants, if not permitted, may amount to deemed admission, and remain unrebutted from the side of the plaintiff. Hence, considering the difference between mere re-examination and the prayer for further cross-examination of such a witness who deposed against the person calling him, the court has permitted the further cross-examination of PW3 by learned counsel for the plaintiff. PW3 deposed that he cannot produce any document to show that the plaintiff does money lending business. PW3 has deposed that the defendant sustained losses in his business. PW3 has also deposed in the cross-examination by the learned counsel for the plaintiff that if he were to produce a license pertaining to the business of defendant 1, he has to ask defendant over telephone, and only thereafter he could depose regarding the production of such document. Thus, it is clear that the witness PW3 is in talking terms with the defendant. Thus, it is relevant to note that he did not express his inability to produce the document of the defendant, but only expressed as to the requirement of consultation of the defendants to the answer the said question. This very fact reflects upon the good relationship between the witness and the defendants. The other two witnesses in Exhibit P2 being the daughters of defendants, the argument of the learned counsel for the plaintiff that the plaintiff cannot expect much from the daughters of the defendant to support the version of the plaintiff, to support the reality of the as forthcoming in Exhibit P2 itself, contrary to the defense raised by the defendants in this regard, seems to be having much force. Therefore, the argument of the learned counsel for the plaintiff that the plaintiff was compelled to secure the presence of PW3 for proof of Exhibit P2 seems to be acceptable. Therefore, merely because PW3 has not fully supported the plaintiff, his evidence insofar as it relates to execution of P2 by the defendants can be relied upon. PW3 has deposed in the chief examination that he has asked as to why the amount of consideration is written as 14 lakhs and why only 10 lakhs is paid in his presence. He has further deposed to the said question. It was his reply that the defendants have already such a recital is written that there is no space for writing anything else. Such a conduct of any contradicting party while dealing with immovable property or while doing the money transaction is highly unnatural. The version of PW3 as above reflects more fully upon the knowledge of the defendants about the recital in PW2 regarding the payment of consideration. The very fact that in spite of knowing about those recitals, they have subscribed the signature and got documents registered without raising a single objection reflects upon the aspect of due execution of Exhibit P2. After understanding the purport and intention of the recitals in Exhibit P2, an educated man or woman having subscribed his or her signature after understanding such contents cannot be held to have not duly executed such a document. Even PW3 himself has read Exhibit P2 and put his signature after understanding its contents. He is very much clear in the evidence of PW3. PW3 has deposed that the defendant 1 has obtained 2 lakhs as loan from him and said loan is not yet repaid. It is suggested to the witness that he had told the plaintiff that he would support the plaintiff if the plaintiff pays 2 lakhs to PW3. But for having denied the said offer, PW3 is deposing falsely against the plaintiff. PW3 has deposed that he has given the said loan about 2 years back, and the defendant has not paid any interest in that regard. He has also stated that he has paid the said loan 2 months prior to Exhibit P2 transaction, and he has not taken any legal action against the defendants in connection with the said loan. He has voluntarily deposed that the defendants has sustained losses in business. To the question put to him as to whether he has taken any legal action against the defendants, thus PW3 has got compassion against the defendant number 1, for defendant number 1 has sustained losses in business. However, PW3 deposed that he is a salaried person drawing a salary of rupees 17,000 per month. The said sum of rupees 2 lakhs is a huge amount for PW3. The defendant 1 is not relative of PW3. Lending 2 lakhs free of interest as loan, but not asking even for a repayment of the principal amount is a conduct which throws light upon close association of PW3 with defendant number 1. That itself reflects as to why PW3 did not support the plaintiff, but made statements favorable to the defendants. However, by way of principle of separating the grain from the share, the evidence of PW3, if considered, the statement of PW3 insofar as they support the version of the plaintiff, are very much relevant and reliable under the circumstances of the case. Therefore, though the evidence of PW3 is not fully favorable to the plaintiff, it contains several aspects which are favorable to the plaintiff, pertaining to the aspect of due execution, that is, knowledge of the defendants regarding the recital of Exhibit P2 prior to subscribing the signature to the document. Therefore, the evidence of PW3 is also helpful to the plaintiff. However, PW3 being a close associate of defendant number 1, his evidence regarding loan transaction is not reliable, as it is contrary to the recital in the registered instrument and unnatural under the circumstances of the case. It is relevant to note that there is no document to show the payment of interest by the defendants towards the loan transaction. The defense that 4 lakhs was deducted at the time of payment itself and not 10 lakhs is paid as principal amount with agreement for repayment shall be rupees 14 lakhs is unnatural theory. In the written statement, it is pleaded that the money of 10 lakhs was lent in the month of December 2014 on the condition of returning it in the month of December 2016, and 4 lakhs was added as interest towards the said loan. If at all the time was given up to December 2016, as pleaded by the defendant, Exhibit P2 should have contained 2 years as the time fixed under the agreement, but not as 1 year. Such fixation of time required no additional assertion regarding a real transaction, if at all the nature of the transaction as alleged by the defendants is considered as true for the sake of the arguments. Therefore, fixing the duration of 2 years by the parties is highly improbable from the recital of Exhibit P2. Therefore, on this count alone, the defense regarding loan transaction is improbabilized. It is argued by the learned counsel for the plaintiff that the money lending, if at all were to be true, the rate of interest would be generally calculated at a particular rate per month. It is also argued that unlike the banks, which change the interest per annum, private transactions such as money lending charges interest per month, and hence taking 2 lakhs as interest for 10 lakhs, the rate of interest would not come to the rate of 2% per month and is more than 1.5% per month. It is, in other words, the rate of interest, if were to be 2% per month, it would come to 24% per annum. The interest of rate, if were to be 1.5% per month, it would amount to 18% per annum. Per contra,
2 lakhs interest for 1 year, if the principal amount is 10 lakhs, would be the interest at the rate of 20% per annum. Therefore, such a rate of interest is inconsistent with the normal rate of interest charged during the money lending in the arguments of the learned counsel for the plaintiff. This argument of learned counsel for the plaintiff is not supported by evidence regarding nature of charging of interest in private money lending transactions. However, the theory of money lending is inconsistent with the theory of the charging of interest for 2 years advance for the duration in Exhibit B2 is mentioned as 1 year. It seems that the defendants have put forth such a theory only to propagate that in view of the duration of the agreement being up to December 2016, there is no document regarding to the payment of either the principal amount or interest as on the date of the suit or on the date of the legal notice. To be precise, such defense raised to overcome the absence of any document regarding the repayment of the money towards the alleged loan transaction. It is relevant to note that the cross-examination DW1 herself expressed ignorance regarding the rate of interest charged in the alleged loan transaction. She has deposed as follows. Thus, DW1 does not know as to the duration for which the alleged 4 lakhs is received as interest. According to DW1, it is a husband who has to the plaintiff in that regard. If that were to be so, DW1 cannot be held to have personal knowledge about the real transaction, for it is not she who actually held the talks for contract with the plaintiff. If that were to be so, DW1 cannot be held to be having personal knowledge about the talks between the defendants and plaintiff. If that were to be so, she would be an incomplete witness to depose about this loan transaction as alleged. Therefore, if the version of DW1 is considered, defendant number 1 not stepping into the witness box is a ground for drawing adverse inference against him. It is not established that the suit property was worth 50 lakhs as on the date of the agreement, Exhibit P2. Therefore, mere defense that the suit property was that much worth cannot be a ground to come to the conclusion that the agreement was in fact a security for loan transaction as alleged. It is relevant to note that DW1 has deposed in the cross-examination as follows. The Exhibit P1 clearly discloses that the kata of the suit property stood in the name of defendant number 1, and as per Exhibit P3, the defendant number 1 has got title deed. Hence, if at all the requirement of the defendants were really the loan, then they could have obtained such loan from any bank is a relevant point. Even as per the version of DW1, a month's time was consumed by the plaintiff. Hence, the urgency pleaded by DW1 is not a proper and convincing theory for taking a loan from the private person. Further, the DW1 is evasive on the point of urgency of loan, which reflects upon the demeanor of DW1 in evading to answer the material question put to her. Thus, the theory of loan seems to be put forth without any substance. Exhibit P2 is original registered agreement. The signatures of defendants found therein are proved through DW1 and PW1 to 3. The defendants have subscribed their signature to Exhibit P2 by understanding the contents of Exhibit P2. Is also emphatically clear and true. The theory of loan transaction pleaded by the defendants is not convincing, and such a theory is improbabilized from the evidence on record. Therefore, due execution of Exhibit P2 coupled with delivery of Exhibit P3, title deed is proved by the plaintiff. Hence, issue number 1 is answered in the affirmative, and issue number 4 and 5 are answered in the negative.
Yes.
Yes. Now, as I submitted, I will just probably it will not take much time to go to the findings insofar as the other issues are concerned, which of course is just one paragraph each.
No need to read. I have gone through the judgment. Proceed with your argument.
Yes. Now, as I submitted
day before yesterday. Our contentions throughout has been that it is a loan transaction and not a transaction for the transfer of the property. And insofar as there are a lot of surmises and conjectures or probably assumptions made by the learned judge for rendering a judgment or a decree against the defendants. Now, having said so, could I request this court to kindly take my application that I have filed along with order and this appeal, in the course of this appeal, under order 41 rule 27. The documents I have placed before this court first document is the invitation card of the wedding of the appellant's daughter.
Before you taking me to the documents which you intend to rely upon, you should address your argument on the IA. That and convincing the court that the IA deserves to be allowed. Only then you can take me to the document.
Very well. Reasoning would probably be this. From the instructions is that the best judgment, it was advised that these documents may not be relevant for the purpose of the trial before the trial. That is the instructions. But however, in order to demonstrate the fact that there was no legal requirement for them to sell the property, however, there was only a small accommodation that is required for the purpose of loan. Therefore, in order to establish this theory, these documents are produced before the court.
Yes.
Documents is only as an explanation to the grounds that is put forth before this honorable court to demonstrate the fact that there was huge amounts that was spent for putting up the construction. Therefore, documents as regards to the construction of the house is concerned is produced before this court. I kindly appreciate that this is the only property that is available to the appellants. And there was no occasion for them to sell this only property. And in order to substantiate this plea of the appellants, the documents are produced before us.
Yes.
The first document is the marriage invitation. The second document is the business that was run by the dependents. Third document is the income tax returns that is filed for the year 2004 and 2005. Document number 4 is the expenses incurred for the putting up of the construction of the only house, that is the suite property. Document number 5 is the completion certificate issued by the engineer. Sorry, document number 5 is the request. Document number 6 is the completion report of the building, wherein they are residing and which is a suite property. Document number 7 is the certificate issued by the corporation bank, wherein the loan was availed for the purpose of putting up the construction of the house. And the closure of the loan that was availed from the corporation bank is the document number 8, and document number 9 is the second daughter's education mass card to demonstrate that she was not studying in the place where the suicidal property is situated, or where the dependents are residing, to show that she was studying elsewhere, and to show bona fides, and of course the taxpayer receipts in pertaining to the only property that is available for these appellants, wherein they are residing, that is the suit property. So therefore, the plea of the the appellants is this: there's only one property for their existence and residence. There was no occasion for them to have entered into an agreement of sale to sell that only property.
Yes.
And as BW3 has also corroborated along with the BW1, there was a small financial adjustment or probably accommodation that was required. Therefore, the defendants have approached the plaintiff in order to obtain the loan, and the plaintiff, being in a dominant position, has taken advantage of this fact and got a document in the style of agreement of sale executed, and it is now sought to be enforced. This is the defense insofar as this thing is concerned. Therefore, the impugned judgment suffers from surmises and presumptions, and the probabilities indicate that there is more of a financial transaction. BW3, being an independent witness called by the plaintiff himself, has deposed against the case of the plaintiff, and therefore the suit ought to have been dismissed. I rest my case for the moment for giving a reply if any. Please,
before commencing arguments on respect to IF filed by the plaintiff's honorable court lordship, I request lordship might kindly see the affidavit filed by the appellant's court honorable. The affidavit, in affidavit, para number 5.
Yes.
The reason why they couldn't file before the trial court. The reason which they have stated before the honorable court is that due to unavoidable reasons. Your lordship, the suit has been filed before the trial court in the year of 2015.
Yes.
They had an opportunity till the end of 2016, and the documents filed before the honorable court is much prior to the 2014. Your lordship might kindly see the first documents produced by the appellant with honorable court is marriage invitation. The marriage was happened in the year of 2008. The agreement as executed in the year of 2014. And their theory before honorable court is to occur the expenses with respect to the marriage, they have obtained a loan as far as their concern. In another document which I have filed by the learned before the appellants before the honorable court is that the documents of other documents with respect to the permanent registration certificate, which is issued in the year of 2000, which was there in the custody of the appellants, and the other documents which are the closure of the loans, everything which prior to 2012, that every document was in the custody of the appellants the time before the before the trial court of Kola, and the intention they have filed these kind of documents along with an application to fill up the lacunas but nothing but to fill up the lacunas. Therefore, I request lordship may kindly dismiss the application. Even the document number 8, which they have clearly stressed upon the document of the closure of the loan. Even the letter issued by the bank, the dated your lordship may kindly see 26/3/2012. Close there was no any urgency with respect to closure of that such kind of loans. Property with such intention they approach the respondent. With respect to that, they have entered into the agreement.
The agreement to sale was dated 3/12/2014 and same was registered on 4/12/2014. It was not disputed, Your Lordship. The same was accepted by the appellant for the trial court and even for the Honorable High Court. And Your Lordship, with respect, prior to filing an institution of a suit, Your Lordship, the defendant has issued a legal notice 17/7/2015 by asking them to come forward to register the property in favor of the defendant. In the entire statements, even the written statement or in the chief of DWR, and everywhere they are contention that issued a legal notice with respect to replay issued by the defendants in favor of the appellants. In their contentions also, they have clearly stated now our legal reply could be idu bandu agreement to for sale alla, with agreement to for loan anta. Nowhere from the trial court till high court, nowhere they are submitted a reply document for the honorable courts, which clearly their admissions with respect to the agreement for a sale. And there was one more contention was just the appellants taken before the trial court was the property value was worth of 50 lakh rupees, not a level of 15 lakh rupees. Even the document which is produced before the honorable court in the additional document, there was like a same contention. Even in a judgment, honorable trial court has taken a contention that even a sufficient time has granted to the defendants before the trial court, it couldn't file and demonstrate the property is worth of 50 lakh rupees. In a even before trial court, Your Lordship, the appellants and the defendants taken a sufficient times to produce their side of the document to demonstrate their side of stance. But they couldn't file even before the honorable High Court also, they didn't file any document to prove or substantiate their stand up. The property is transferred 50 lakh rupees.
If the defendant by any chance could able to produce the documents or the evidence to show that the property was worth more than 15 lakh rupees, which was the agreed sale consideration, what could have been the position of the agreement?
It's their choice before entering into the agreement whether to sell their own property to some other body, whether it's about 10 lakh rupees or 15 lakh, it's their own choice to sell the property. They're according to their own consideration somewhat. The agreement to sale, by the time of entering the agreement, entire amount except 1 lakh rupees, the entire sale consideration amount has been received by the appellants before entering into the agreement. Even after the judgment has passed by the trial court, within a stipulated, within a 1 month, the defendant has deposited 1 lakh rupees. Saying the majority of the final argument, the appellants come forward to deposit the amount before the honorable High Court, filing an application seeking to deposit the amount. I will detail objection before the honorable High Court why the same application will not be allowed. Lordship, the suit was filed in the year 2015. It was come to finally at the of 2016. They have come before honorable High Court in 2017. Till 2020-22, they have not even made a single attempt to make these kind of submissions or submit or deposition of such kind of 14 lakh rupees in trial court, not before the High Court. After obtaining a interim order in their favor in the year of 2017, they have not made a single memo before the honorable court by seeking an urgency or to demonstrate their stance before the honorable. After allowing the application by this honorable court, as clearly observed, Lordship, in the order dated 27/9/2022, I would request Lordship kindly look into the order. The paragraph order dated 27/9/2022. High Court 27/9/2022. The matter was listed on that particular day for final arguments.
Yes.
The 5th paragraph, Your Lordship, as stated earlier, comments from very much before the IA number 1/2000 is allowed. Our paragraph ali Honorable High Court has clearly
Yes.
that the order passed by the Honorable High Court has clearly taken a contention. It's made clear, Lordship, it's made clear that no advantage would be caused or would be benefited to appellant in deposit the amount with regard to the main appeal or merits of the matter.
Which para you are reading? Which page and which para?
Dated ಮಾತ್ರ ಇದೆ. ಐದನೇ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಂತ ತೋರಿಸಿದೆ. Of the order, IA hence IA number 1 of 2022 is allowed ಅನ್ನೋದ್ರ ಮೇಲೆ ಮೇಲೆ ಇರೋ ಪ್ಯಾರಾಗ್ರಾಫ್. Clear observation ಇದೆ. ಈ ಡೆಪಾಸಿಟ್ ಮೇಲಿಂದ ಯಾವುದೇ ಅಡ್ವಾಂಟೇಜ್ ತಗೋಬಾರ್ದು ಅಂತ. That's my submission. Page 36 continuation. But on the Lordship, I request Lordship my kindly see the page number 36 of booklet. Judgment, ink page number 20.
Yes. Yes. Which para?
Entire on the paragraph. 26 song. Page number 24.
You are referring to judgment. What is the internal page of the judgment?
24 song.
24. Yes.
It starts from the main line song.
Yes.
The very fact that in spite of knowing about the recitals, they have subscribed their signature and got document registered without raising a single objection reflects upon the aspect of due examination of exhibit B. Idallo agli, even before the sub-register agli, even before the court agli, they will never raise a single objection before entering into agreement or executing the agreement, which clear and admission on their side, they are ready to sell the property. Hence, they have agreed to registered or execute the agreement to sale. Next page, Lordship.
Yes.
And another friend had taken a contention that the execution period is 1 year. It was not 2 years. In their own statement, in the return statement, in page number 20, Swami, they have clearly taken a contention that in the return statement, it is pleaded that the money of 10 lakh was lent for the month of December 2014 on a condition of return in the month of 2015. Their own contentions. ಅದಕ್ಕೆ ಕಾಂಟ್ರಾಡಿಕ್ಟ್ ಆಗಿ they have request Lordship may kindly turn the judgment in page number 31 on the cross examination the DW1 mentioned in Kannada.
Yes.
Request to the paragraph. ಸದರಿ ಸ್ವತ್ತಿನ ಖಾತೆ ಹಾಗೂ ಕ್ರಯಪತ್ರ ನನ್ನ ಗಂಡನ ಹೆಸರು ಇತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸಾಲವನ್ನು ಮಾಡಬೇಕಿದ್ದಲ್ಲಿ ಯಾವ ಬ್ಯಾಂಕಿಗೆ ಹೋದರೂ ಸಾಲ ಸಿಗುತ್ತಿದ್ದರು ಎಂದರೆ ನಿಜ. ಸಾಕ್ಷಿ ಸ್ವತಃವಾಗಿ ನುಡಿಯುತ್ತಾರೆ, ಆದರೆ ನಮಗೆ ಸಾಲ ಬಹಳ ಅರ್ಜೆಂಟ್ ಆಗಿ ಬೇಕಿತ್ತು. ಏನಕ್ಕೆ ಅಂದ್ರೆ ಏನಕ್ಕೂ ಕಂಟೆನ್ಷನ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ನನ್ನ ಮಗಳ ಮದುವೆಗೆ ಬೇಕಾಗಿತ್ತು, which is happened in the year of 2008. They entered the agreement in 2014. ಇಲ್ಲಿ ಬಂದು ಏನಕ್ಕೋ ಬೇಕಾಗಿತ್ತು. They are very contradictory to their own statements ಎಂದು ನುಡಿಯುತ್ತೇನೆ. ಇದಕ್ಕಂತೆ ಎಂದು ಹೇಳಲು ಸಾಧ್ಯವಿಲ್ಲವೇ ಎಂದು ಹೇಳ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅಂಜಿನಪ್ಪನವರು ನಾವು ಸಾಲ ಕೇಳಿದ್ದು 1 ತಿಂಗಳಲ್ಲಿ ಸಾಲ ಕೊಟ್ಟಿದ್ದರು, ವಾದಿ ನಮಗೆ ಸಾಲ ಕೊಟ್ಟಿದ್ದು ಅಂದರೆ ಸರಿಯಲ್ಲ. ಬ್ಯಾಂಕ್ ನಲ್ಲಿ 3 ದಿನ ಸಾಲ ಸಿಕ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. should they have obtained the loan prior to entering into the agreement for sale? Clear that even having a knowledge how to obtain a loan, then again, nobody would be appear or obtain a loan from the regular lenders also. And the plaintiff or the respondent is not a lender. Even the submission made by the learned friend with respect to PW3 witness, it clearly demonstrated in the judgment and the statement of the PW3, it's very clear that he is a very close associate with the DW1. Hence, he has been made hostile and does the same.
Yes.
I rest my case with by making the submission. Idರಲ್ಲಿ ಯಾವುದೇ ಆಗಲಿ agreement for sale ಬಿಟ್ಟು there was no such kind of alleged transaction as made by the appellants before the court. Hence, I request Lordship can you dismiss the appeal with the cause.
Any reply? Hey, proceed with the reply. There are counsel from both sides present. The further argument of the counsel for the appellant, respondent's argument and reply. Judgment is up. Yes. ಈ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಕರೀಲಿಕ್ಕಿರೋದ್ರೆಲ್ಲ ಮುಂಚಿನ ಕರಿ.
Number 11. Jay Prakash Rao, please basically for R14 and R15.
Called again. None of the 11 Registrar General has submitted. Filed his written submission. Granted, in the absence of further complaints, the matter could not be proceeded to. Yes.
These two
I never accept any judgment which have not been relied upon in the argument. In the argument, only those judgments which have relied upon in the argument brought the relevant portions to the notice of the court. Other side is given an opportunity to meet them. Only they will be considered. Not say keeping a bunch after the argument. I never have accepted, never I accept also. Yes.
Still number 15, Sri S. Kalyan Baswaraj.
The mistake.
Called again, counsel for the appellant submits that he would not press. Submits that since he is required to file an application seeking treating of respondent number 1 to 3 as the legal representatives of deceased respondent number 4, he would not press the memo filed to that effect. In view of the above submission, the said memo stands disposed as not pressed.
Still number 16, Sri S. Kalyan Baswaraj.
All connected lines.
Still number 17.
ಹೀಗೆ ಕೊಟ್ಟರೆ ಬರ್ತದೆ. ಹಾಗೆ ಕೊಟ್ಟು ಸುಲಭದ ಕೆಲಸ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿಗೆ ಹೋಗ್ತದೆ.
Case number 18. Kalyan Vasanthi. Case number 19.
ಮೆಮೊ ಕೊಡಿ. In addition to that, in spite of making a detailed observation on 22/6/2023 and granting one more opportunity for the appellant to take the steps to ensure the service of notice upon unsolved respondent number 3, the appellant has not taken any step, which itself would go to show that the appellant is not evincing interest. That accordingly, the appeal as against respondent number 3 stands dismissed for not taking step. In the light of the dismissal of the appeal as against respondent number 3, the maintainability of the appeal as against the remaining respondents is also required to be further considered at the appropriate stage. Yes.
Number 20, Sri B.S. Prasad.
Again. Counsel for the appellant, neither present physically nor through video conference. Learned counsel for respondent. Respondent number 1 alone present. In spite of granting several and sufficient opportunities.
I taken a step.
When have you taken step?
2020, I taken a step. Last case matter listed. That I'm not.
5 seconds ಬೇಕಾದ್ರೆ ಕೂತ್ಕೊಳ್ಳಿ ಸುಧಾರಿಸ್ಕೊಳ್ಳಿ ಓಡಿ ಬಂದಿದ್ದೀರಿ. ನೀರು ಬೇಕಾದ್ರೆ ಕುಡೀರಿ ಕೊಡ್ತಾರೆ.
respondent 3 is concerned, my lord, he is not in place, my lord. I intimate High Court advocate also, my lord. 2 days time away, my lordship, I furnishing the correct response.
ಈಗ ಅದೆಲ್ಲದನ್ನು ಬರ್ಸಿನೇ ನಾನು ಆರ್ಡರ್ ಮಾಡ್ತೇನೆ. ನೀವೇನ್ ಕೇಳಿದ್ರಿ, ನಾನು ಏನ್ ಬರ್ದಿದ್ದೇನೆ ಹೋದ್ ಸರ್ತಿ ಎಲ್ಲದನ್ನು ಕೇಳಿನೇ ಮಾಡ್ತೇನೆ. ಕೇಸ್ ಹೇಗೆ ನಡೆಸಬೇಕು ಹೇಳಿ ವಕೀಲ್ರಿ ನೋಡೋಣ. ನಿಮ್ಮ ಆಫೀಸ್ನಲ್ಲೇ ಎಷ್ಟು ಮ್ಯಾಟರ್ಗಳು ನನ್ನ ಎದುರು ಬರ್ತಾ ಇದೆ. ಒಂದ್ರಲ್ಲಾದ್ರೂ ಐ ಹ್ಯಾವ್ ಡನ್ ಅನ್ನೋದನ್ನ ಹೇಳಿದ್ದೀರಾ? ಇಲ್ವೇ ಇಲ್ಲ. ಮಾಡ್ತೇವೆ, ವಿಲ್ ಬಿ ಡನ್, ಇಟ್ ವಿಲ್ ಬಿ ಡನ್, ಅಸರ್ಟೈನ್ಡ್, ವಿ ಹ್ಯಾವ್ ಆಸ್ಕ್ಡ್ ದಿ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್. ಅಲ್ರಿ, ನಿಮ್ಮನ್ನು ನಂಬಿ ಕಕ್ಷಿದಾರರು ಲಕ್ಷಾಂತರ ರೂಪಾಯಿ ಫೀಸ್ ಕೊಟ್ಟು ಕೇಸ್ ಬೇಗ ನಡೀತದೆ ಅಂತ ಹೇಳಿ ವಕೀಲರು ಇಟ್ಟಿರ್ತಾರೆ. ವಕೀಲರು ಬರ್ತಾರೆ ಅಂತ ನಾವು ಕೂರ್ತೀವಿ. ನೀವು ಕೇಸ್ ನಡೆಸಿದ್ರೆ ನಮಗೆ ಕೆಲಸ ಇದೆ. ಸಣ್ಣ ಸಣ್ಣ ವಿಷಯ 2017 ಇಸ್ವಿ 6 ವರ್ಷ ಆಗಿದೆ. ಎದುರು ಪಾರ್ಟಿಯವರಿಗೊಂದು ನೋಟಿಸ್ ಹೋಗ್ಲಿಲ್ಲ. ಯಾರಿಗಿದೆ ಇಂಟ್ರೆಸ್ಟ್ ಹೇಳಿ? ಕೇಸ್ಗಳನ್ನ ಪೋಸ್ಟೇ ಮಾಡಲ್ಲ. 4,500 ಕೇಸ್ಗಳು 5 ವರ್ಷ 6 ವರ್ಷದಿಂದ ಬೆಳಕೆ ಕಂಡಿಲ್ಲ. ಇನ್ನು ಹಳೆ ಕೇಸ್ಗಳು ಎಷ್ಟಿದೆ ಗೊತ್ತಿಲ್ಲ. ನನಗೆ ಕೊಟ್ಟಿರೋದು 2017 ಇಂದ ಈ ಅಪೀಲ್ಗಳು. ಇದಕ್ಕಿಂತ ಹಳೆ ಅಪೀಲ್ ಬೇರೆ ಜಡ್ಜ್ ಎದುರು ಇದೆ. ಆ ಹಣೆ ಬರ ಏನಾಗಿದೆ ಗೊತ್ತಿಲ್ಲ. ನನ್ನೆದುರು ಬರ್ದಿರೋ ಕೇಸ್ಗಳನ್ನ ನನ್ನ ಈ ರೋಸ್ಟರ್ ಬರ್ಲಿಕ್ಕೆ ಮುಂಚೆ ಎಂಟೈರ್ ಲಿಸ್ಟ್ ತರಿಸ್ತೇನೆ. ಪ್ರತಿ ಸರ್ತಿ ಯಾವುದೇ ರೋಸ್ಟರ್ಗೆ ಹೋದ್ರು ನಾನು ಮೊದಲನೇ ಮಾಡೋ ಕೆಲಸ, ನನಗೆ ಅಲಾಟ್ ಆಗಿರ್ತಕ್ಕಂಥ ಕೇಸ್ಗಳು ಟೈಪ್ ನಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಕೇಸ್ಗಳು ಪೆಂಡಿಂಗ್ ಇದೆ ಎಂಟೈರ್ ಲಿಸ್ಟ್ ಕೊಡಿ ಅಂತ. ಆ ಲಿಸ್ಟ್ ತರಿಸಿದ್ರೆ ನನಗೆ ಶಾಕ್ ಆಯ್ತು ನೋಡಿ. 2017 several thousands of cases. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಲಿಲ್ಲ. ಕೇಸ್ ಹಾಕಿ ವಕಾಲತ್ ತಗೊಳ್ತೀರಿ, ಏನೋ ಮೆಮೊರಾಂಡಮ್ ಮಾಡ್ತೀರಿ, ಬಿಸಾಕ್ತೀರಿ, ತಣ್ಣಗೆ ಕೂರ್ತೀರಿ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಲ್ಲ. ಏನಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಗಳು? ಸ್ಟಿಚ್ ಮಾಡಿದ್ ಸರಿ ಇಲ್ಲ, ಹೊಲಿಗೆ ಬಿಟ್ಟು ಹೋಗಿದೆ, ಹೊಲಿಗೆ ಸರಿ ಹಾಕ್ಬೇಕು, ಪೇಜ್ ನಂಬರ್ ಹಾಕಿಲ್ಲ, ವಕೀಲರು ಸೈನ್ ಮಾಡಿಲ್ಲ, 1 2 3 4 ನಂಬರ್ ಹಾಕ್ಬೇಕು, ಪಕ್ಷಗಾರರ ಹೆಸರು ಪಕ್ಕದಲ್ಲಿ 1 2 3 4 ನಂಬರ್ ಹಾಕಿಲ್ಲ. ನರ್ಸರಿ ಸ್ಕೂಲ್ ಮಕ್ಕಳು ಮಾಡೋದು, ನರ್ಸರಿ ಸ್ಕೂಲ್ ಮಕ್ಕಳು ಮಾಡೋದನ್ನ ವಕೀಲರು ಮಾಡಲ್ಲ. ಇದು ಟೈಮ್ ಅಡ್ಜರ್ಮೆಂಟ್ 5 ವರ್ಷ 6 ವರ್ಷ 7 ವರ್ಷ. ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಭಾರತದ ಪ್ರಜೆಗಳು? ನ್ಯಾಯ ಕೇಳ್ಕೊಂಡು ಬರೋರು ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು? ಕೇಳಿದ್ರೆ ಕೋರ್ಟ್ ತಗೊಳಲ್ಲ. ಏನ್ ಮಾಡುದು? ಕೋರ್ಟ್ ಎದುರು ಬಂದಿಲ್ಲ, ನಾವೇನ್ ಜಡ್ಜೇನು? ನಾವು ಜಡ್ಜ್ ತಗೊಂಡಾಗ ಬರುತ್ತೆ. ಏನೋ ಹೇಳ್ತೀರಿ, ಏನೋ ನಂಬಿಸ್ತೀರಿ. ಸ್ವಲ್ಪ ಪ್ರಾಥಮಿಕ ಶಿಸ್ತು, ಕಾರ್ಯತತ್ಪರತೆ. ಎಲ್ರು, ನೀವು ನಾವು ಸಿಬ್ಬಂದಿಗಳು ಬೆಳೆಸ್ಕೊಂಡ್ಬಿಟ್ರೆ ಎಂಥ ಅದ್ಭುತ ಪವಾಡ ಮಾಡಬಹುದು. ನಮ್ಮಲ್ಲಿ ಕಾನೂನಿಗೆ ಕೊರತೆ ಇಲ್ಲ, ಹಣಕ್ಕೆ ಕೊರತೆ ಇಲ್ಲ, ಮ್ಯಾನ್ ಪವರ್ಗೆ ಕೊರತೆ ಇಲ್ಲ. ಹೋಗ್ಬೇಕಾಗಿರೋದು ಉದಾಸೀನ ಪ್ರವೃತ್ತಿ. ನಮ್ಮಲ್ಲಿರೋದು ಅತ್ಯಂತ ದೊಡ್ಡ ಕೊರತೆ ಅಂದ್ರೆ ಉದಾಸೀನತೆ ಬಿಟ್ಕೊಡೋದು. ಅದಿಲ್ಲ. ಆ ಉದಾಸೀನತೆಯಲ್ಲಿಯೇ ಮಾಡ್ಬೇಕು. ಮ್ಯಾಟರ್ಗಳು ಲಿಸ್ಟಿಂಗ್ ಆದ್ರೂ ಮಾಡ್ರಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ರು ಮಾಡಲ್ಲ ಲಿಸ್ಟಿಂಗ್. ಬ್ಯಾಡ್ದ ಇರೋರ್ಗು ವಾರಕ್ಕೊಂದೊಂದ್ಸರ್ತಿ ಹಾಕ್ತಾರೆ ಕೇಸ್ಗಳು. ವಾರಕ್ಕೊಂದ್ಸರ್ತಿ ಬರೋ ಅವಶ್ಯಕತೆನೇ ಇರಲ್ಲ, ಅದು ಸುಮ್ಮನೆ ಹಾಕ್ತಾರೆ. ಬೇರೆ ಕೇಸ್ಗಳು ಹಾಕ್ರಪ್ಪ ಅಂತ ಹೇಳಿದ್ರು 4 ವರ್ಷ 5 ವರ್ಷ ಆದ್ರೂ ಕೇಸ್ ಹಾಕಲ್ಲ. ಕೇಸ್ ಹಾಕಲ್ಲ ಅಂತ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಬರೆದ್ರು ಏನು ಉಪಯೋಗ ಇಲ್ಲ. ಬಂದಿದೆ ನೋಡಿ 6 8 10 ಮ್ಯಾಟರ್ ಈಗ ಬಂದಿದೆ. 7 ವರ್ಷ ಆಯ್ತು ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ ಆಗಿ, ನಾನು 23 ವರ್ಷ ಆಯ್ತು ಜಡ್ಜ್ ಆಗಿ. ಒಂದೇ ಒಂದು ನಮ್ಮ ನೋಟಿಸ್ ಮೇಲೆ ಒಬ್ಬ ಸಿಬ್ಬಂದಿ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡಿದ್ರೆ ತೋರಿಸಿ ನೋಡೋಣ. ಯಾವಾಗ ನಾವು ಏನ್ ಮಾಡಿದ್ರು ನಮ್ಮ ಮೇಲೆ ಯಾರು ಏನು ಕ್ರಮ ತಗೊಳ್ಳಲ್ಲ ಅಂತ ಗೊತ್ತು, ಕೆಲಸ ಯಾಕೆ ಮಾಡ್ತಾರೆ ಅವರು? ಪರಿಣಾಮ ಏನಾಗುತ್ತೆ? ಕಕ್ಷಿದಾರಿ ನ್ಯಾಯ ಸಿಗಲ್ಲ. ನಾವು ನೀವು ಎಲ್ಲ ಹೋಗಿ ಭಾಷಣ ಬಿಗಿತೇವೆ, ಹಾಗೆ ಹೇಗೆ ಭಾರತದ ಸಂವಿಧಾನ ಆರ್ಟಿಕಲ್ 14 ಈಕ್ವಾಲಿಟಿ ಬಿಫೋರ್ ಲಾ, ಆರ್ಟಿಕಲ್ 19 ರೈಟ್ ಟು ಲೀವ್, ರೈಟ್ ಟು ಕ್ಯಾರಿ ಎನಿ ಪ್ರೊಫೆಷನ್ ಆರ್ ಟ್ರೇಡ್,
ಏನ್ ಅರ್ಥ ಇದೆ ಈ ಭಾಷಣಗಳಲ್ಲಿ? ಬೇಜಾರಾಗ್ತದೆ. ಯಾವಾಗ ರಿಟೈರ್ ಆಗ್ತೇನೆ ಕಾಯ್ತಿದ್ದೇನೆ. ಕೆಲಸ ಮಾಡ್ಬೇಕು ಅಂತಿರೋರಿಗೆ ಸೂಕ್ತ ಪರಿಸರ ಬರದೇ ಹೋದ್ರೆ ಬಹಳ ಕಷ್ಟ ಆಗ್ತದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೇನೆ ನಿಮಗೆ ಡೇಟ್ ಟೈಮ್ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿ. As finally a week's time is granted to the appellant to take fresh steps and ensure the service of notice upon unsolved respondents, failing which the court may proceed to pass appropriate order including dismissal of the appeal as against the unsolved respondents. ಅಷ್ಟು ಎಲ್ಲ ಬರ್ಸಿದ್ರು ಕೂಡ ಏನಿಲ್ಲ 2 more days ಅಂತೆಲ್ಲ ಹೇಳಿದ್ರೆ ಏನ್ರಿ ಕೇಳಲಿಕ್ಕೆ ಸಂಕೋಚ ಬೇಡವೆ? ಬರ್ಕೊಳ್ಳಿ. ನನ್ನ ಪೇರನ್ನ ತೆಗಿರಿ. Called again in the afternoon, learned counsel for the appellant and respondent number 1 present. The learned counsel for the appellant once again prays for some more accommodation to take fresh steps to unsolved respondent number 2 and 3. A perusal of the order sheet would go to show that the appeal is of the year 2017. As such for the past 6 years, the appellant has not ensured the service of notice upon all the respondents. On 22/6/2023, this court had made observation to that effect as below. Muted comma, dot, dot. As finally, a week's time is granted to the appellant to take fresh steps and ensure the service of notice upon unserved respondents, comma, failing which, comma, the court may proceed to pass appropriate orders, including the dismissal of the appeal as against the unserved respondents. Close inverted comma. Dot, dot, close inverted comma. In spite of the same, the appellant has not shown any inclination of taking steps which has resulted that respondent number 2 and 3 have still remained unserved. No steps have been taken to ensure the issuance of notice to them. Hence, in this appeal of the year 2017, I am of the view that there is no point in granting some more time, though it is prayed. As such, the appeal as against respondent number 2 and 3 stands dismissed for not taking steps. Next line. In the light of the dismissal of the appeal as against respondent number 2 and 3, the maintainability of the appeal as against the remaining respondents is required to be heard at the appropriate stage. Yes.
Seal number 70, Sri R.V. Devaprakash, Sri N. Timmayagoda for R1, M.V. Cherati for R2.
Yes.
surveyor as commissioner on measuring the.
I did not make use of any word, a commissioner or a surveyor. I only suggested that say the parties, if both the parties are desirous, matter can be reverted back to the trial court, enabling both the parties to request for appointment of a commissioner for local inspection, who can visit and demarcate where 85/1 and 85/2 ends and where your park begins. That was it. Since your approved layout plan says there is park approved. His survey at exhibit P10 shows that he has got a land of a particular extent, but none of the documents in P series or D series says where your boundary ends and where his boundary commences. Therefore, it's only through the local inspection can be done. Otherwise, through the documents, one can say, yes, the plaintiff has got 1 acre 39 guntas or whatever it may be, 1 acre 39 guntas of property. And he have got an approved plan. Since he has come to the court, alleging some interference in his possession, and it is a suit for bare injunction, not for any title. Okay, fine. He has shown the document of the ownership with respect to a particular measurement. He alleges interference. Easiest way would be to hand wash by granting injunction. That happens in several of the matters. But actually, the reality would be something different there. So that is what the court suggested. It was not a compulsion, it was only a suggestion. Yes. What was the outcome?
No objection for commissioner. That is ADL for the purpose of measuring the land, both the lands and fixing the boundaries. In that regard, I am putting it also.
Without copy to other side?
Sir, we have also no objection to appoint.
Then memo note. We'll see whether the memo would do. I don't appoint commissioner here in this appeal, though in very rare cases that can be done. But say me appointing a commissioner here and keeping this appeal pending or in abeyance would nothing but say making this appeal an old appeal once again. Because nearly 99.99% of the commissioner report to whom the report is not palatable, he opposes that report. Wants to examine the commissioner, wants to file his objection, examine the commissioner, appointment a re-commissioner, a fresh commissioner, etc., etc. All those things I am aware of. That is not the job of the High Court. That's not the job of the High Court. If both of you agreeable for remanding the matter by setting aside the impugned decree, retaining the evidence hitherto led intact, both oral and documentary, along with the pleadings, with only a liberty to the parties to make an application seeking appointment of a local commissioner, and if the local commissioner is appointed, the trial court to proceed further from the stage where the local commissioner is appointed. So that will protect the interest of both the parties also, including their pleadings. If I set aside the matter in simplicity with a mere direction that say commissioner be appointed, maybe even pleading may also be substituted in the guise of the amendment. Can't be done.
Classification this honorable court expressed the opinion that so far as the findings on issue number 1 retained and remaining the interference issue, they remanded to the trial court. That is the expressed last.
so far as the interference of the.
Not sure, I am not remembering whether I had opined that the finding on issue number 1 can be retained. If that were to be the case, you should have encashed the offer on the last occasion itself. Now I don't remember, but I clearly remember that what the court suggested on that day is remanding the matter back only with an observation that say the finding on the issues is set aside with the liberty to parties to apply for the appointment of local commissioner. In such a case, the trial court to consider the said application in accordance with law. If the local commissioner, the commissioner for local inspection is appointed, then the court to proceed further in the matter after securing the report. However, the pleadings of the parties and the evidence led hitherto, both oral and documentary, remains as they are without being varied or set aside by virtue of this order. That is all. So now you are adding something that if the court opined that issue number 1, finding on issue number 1 would be retained. Not sure. I'm not remembering. If that is a thing can be done. Otherwise, absolutely no problem. Already substantial argument is over. You can continue to conclude the argument also. It is for reply argument now. Whom you appear for?
Submission if I'm permitted to make. Lord, I had taken up the application and my written statement, stating that the suit filed against the PDA is not maintainable in view of non-issuance of section 64 notice. But at the time of that particular issue was not framed, and Lord, the decree is granted against me, saying that all the defendants are restrained from hearing the property. So far as section 125 of the Lord Cities Act, there is a finding with regard to that. There is an additional issue framed. But however, insofar as the issue with regard to maintainability of the suit under section for non-issuance of a section 64 notice under the PDA Act, because why I am raising this ground is the alleged interference.
No, 1 second. You said whom you are appearing for?
I represent Bangalore Development.
Bangalore Development Authority has remained unrepresented as per the cause list. R2, yes, R2 is represented. R3 is represented. Yes, R2 is being represented.
R3 is common plan.
Yes.
So far as not my contention in the written statement at page 51. At page 51. ಎರಡನೇ ಮತ್ತು ಮೂರನೇ ಪ್ರತಿವಾದಿಗಳು ತಮ್ಮ ಲೆಕ್ಕಿತ page judgment, the written statement, they are not made it as part of the paperwork. of this contention. Four. The issue was framed only with regard to the maintainability of the suit under section 1 for is the appellate here.
Section 64 BD Act ಅಂತ 20 ಸರ್ತಿ ಹೇಳ್ತಿದ್ದಾರೆ. ನೀವು ಹಾಗೆ ನಿಂತಿದ್ದೀರಿ.
Before the text, we keep rectification. Should I notice before this?
So section 125
is for the
Societies Act, how that is applicable?
The present appellant is the society registered under the.
They had taken that contention.
They had taken that contention. So far as I am concerned, I had taken that contention. Section 64 may kindly be read. Notice which has been now referred to is issued in the year 2010. Is of the year 2012. So far as the 120 pay notice, they have filed application as 7 to 11D. The same was rejected on 24 to 2014.
1 second, I hear once.
I may permit it. No suit or other proceedings shall be commenced against the authority or any member or any officer or servant of the authority or against any person acting under the directions of the authority. The member or an officer of the authority for anything done or purporting to have been done in pursuance of the act or a rule, regulation or a bylaw made thereunder without giving to the authority 1 month's previous notice in writing of the intended suit or other proceedings and of the cause thereof, nor after 6 months from the accrual of the cause of action, such a suit or other proceedings, nor after tender of sufficient evidence. But here, the notice what is being referred to, Exhibit 13 is issued in the year 2010. Present suit is filed on.
Which is that exhibit?
P13.
Suit was filed on
12/4/2012.
So by that time the notice was expired.
Yes, that is after 6 months.
Yes.
They are agreeing for the demand and not at least right, or your at least refer it to the adjudication of that issue also directly to trial court. Your lordship can here itself is not decided. But since it's not my appeal, not
then anyway you have commenced your argument and addressed to some extent, conclude your argument, we will dispose the matter on merit only.
Both the parties are agreed to appoint the court commission. It will remain the matter to the appoint the court commission and ascertain which of the properties are encroached and other.
Yes, Mr. Counsel, what is your submission?
Before their submission, another one more submission is they are contending that 125 notice is not issued to the cooperative society, etc. And they have filed one of the application of the 7th.
No, you are blowing hot and cold. You are continuing the argument and simultaneously you are requesting for remand.
Sorry.
If you are continuing, I am ready to hear. The court is ready to hear.
Sorry.
Pleadings and evidence. No, that so far as contentions are concerned, the appellant's
His submission now is that if the court is of the view that the matter can be remanded with liberty to seek for the appointment of a local commissioner, he is welcoming that.
Yes.
After hearing some time today, what development that took place, I said the court opined that the matter can be decided on merit also. Now, just to know, couple of seconds back, the learned counsel submitted that the matter be remanded with an observation for appointing the commissioner for local inspection. He said it was the joint submission of both yourself, society and him. If that were to be the thing, without touching other aspects, I can remand the matter. Otherwise, since I have heard your argument in full and his argument substantially and his argument just now one submission, I can continue hearing him and proceed on the merit. I leave it to you. Mainly, both of you. His role is minimum, except stating that discharge the BDA because there is no complaints of section 64. Please. Please.
The other day, I had not made submission with regard to, even before that, your lordship called upon the other side to say how whether there is any evidence to show that the dependent society has improved upon that, and then he continued his argument. But in the meanwhile, we have taken up a specific contention in the return statement and also an issue that been framed with regard to the maintainability of the suit on the ground that section 125 notice has not been issued as contemplated under section 125 of the Karnataka Cooperative Societies Act. That was one of the contentions. Well, that contention has been negative on the basis of exhibit P13, a notice issued. But this is not a notice as contemplated under section 125 of the Karnataka Cooperative Society Act. The trial court also says that this contention has been negative while rejecting the application filed under Article 7 Rule 11.
Where is the finding on the additional issue?
Finding on the.
Yeah, in the improved judgment, and what is the finding? The internal page of the judgment or the paragraph number?
Paragraph 11.
11.
ಒಂದನೇ ಪ್ರತಿವಾದಿ ತನ್ನ ಲಿಖಿತ ವಾದಿ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಸ್ಥೆ ಕಾಯ್ದೆ 59 ಕಲಂ 125 ಪ್ರಕಾರ ಒಂದನೇ ಪ್ರತಿವಾದಿ ದಾವಾ ಪೂರ್ವ ನೋಟಿಸ್ ನೀಡಿದ ಕಾರಣ ವಾದಿಯ ದಾವೆ ಆದರೆ ಈ ದಾವೆ ದಾಖಲಿಸುವುದಕ್ಕಿಂತ ಮೊದಲೇ ವಾದಿ ಒಂದನೇ ಪ್ರತಿವಾದಿ ದಿನಾಂಕ 15/9/2019 ನೋಟಿಸ್ ನೀಡಿರುವ ಬಗ್ಗೆ ವಾದಿ ನಿಶಾನೆ B13ರಂತೆ ನೋಟಿಸ್ನ ಕಚೇರಿ ಪ್ರತಿ ಹಾಜರುಪಡಿಸಿದ್ದಾರೆ. ವಾದಿ ಈ ದಾವೆಯನ್ನು ದಿನಾಂಕ 12/4/2012 ದಾಖಲಿಸಿದ್ದು ನಿಶಾನೆ B13 ನೋಟಿಸ್ ದಿನಾಂಕ 15/9/2010 ನೀಡಿದ್ದು, ಆದ್ದರಿಂದ ಈ ದಾವೆ ದಾಖಲಿಸಿದಂತ ಮೊದಲೇ ವಾದಿ ಪ್ರತಿವಾದಿಗಳಿಗೆ ಸದರಿ ನೋಟಿಸ್ ನೀಡಿದ್ದರು ಎಂದು ಕಂಡುಬರುತ್ತದೆ. ನಿಶಾನೆ B13 ನೋಟಿಸ್ ಅಂಚೆ ದ್ವಾರ ಕಳಿಸಿರುವುದಕ್ಕೆ ನಿಶಾನೆ 14ರಂತೆ ಅಂಚೆ ರಸೀದಿಯನ್ನು ಜಾರಿಯಾಗಿರುವುದಕ್ಕೆ B15 ಮತ್ತು 16ರಂತೆ ವಾದಿ ಅಂಚೆ ಹಾಜರುಪಡಿಸಿದ್ದಾರೆ. ಅಲ್ಲದೆ ನಿಶಾನೆ B13 ನೋಟಿಸು ಪ್ರತಿವಾದಿಗೆ ಜಾರಿಯಾಗಿದ್ದು, ಒಂದೇ ಪ್ರತಿವಾದಿ ಆ ನೋಟಿಸ್ ಉತ್ತರಿಸಿರುವುದಕ್ಕೆ ನಿಶಾನೆ B18ರಂತೆ ಕಾಗದ ಪತ್ರ ಹಾಜರುಪಡಿಸಿದ್ದಾರೆ. ನಿಶಾನೆ B13 ಪರಿಶೀಲಿಸಿದಾಗಿ ವಾದಿಯು ಬ್ಯಾಟರಾಯನಪುರ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 85 ಹಾಗೂ 85/233 ಮಾಲೀಕರಿದ್ದು ಸ್ವಾಧೀನ ಹೊಂದಿದ್ದಾರೆಂದು ಆಸ್ತಿಯನ್ನು ಬಿಡಿಎದವರು ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡಿರುವುದೆಂದು ಒಂದನೇ ಪ್ರತಿವಾದಿ ಸೊಸೈಟಿಗಳಿಗೆ ಸದರಿ ಆಸ್ತಿಯು ಯಾವುದೇ ಹಕ್ಕು ಸಂಬಂಧ ಸ್ವಾಧೀನ ಇಲ್ಲವೆಂದು ಹೀಗಿರುವಲ್ಲಿ ಒಂದನೇ ಪ್ರತಿವಾದಿ ಸದರಿ ಸಂಬಂಧಿಸಿದಂತೆ ಬಡಾವಣೆ ನಕ್ಷೆಯನ್ನು ಮಂಜೂರಾಗುವುದು 2 ಮತ್ತು 3ನೇ ಪ್ರತಿವಾದಿಯನ್ನು ಸಂಪರ್ಕಿಸಿರುವುದು ವಾದಿಗೆ ತಿಳಿದು ಬಂದಿದ್ದು, ಅಲ್ಲದೆ ವಾದಿ ಆಸ್ತಿಯಲ್ಲಿ ಅಕ್ರಮವಾಗಿ ಪಾಸ್ ನಂಬರ್ 4 ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿದ್ದು, 1ನೇ ಪ್ರತಿವಾದಿಗೆ 2 ಮತ್ತು 3ನೇ ಪ್ರತಿವಾದಿಗಳು ಬಡಾವಣೆ ನಕ್ಷೆಯನ್ನು ಮಂಜೂರು ಮಾಡಿರುವ ವಿಚಾರ ವಾದಿಗೆ ತಿಳಿದಿಲ್ಲ. ವಾದಿ ಸರ್ವೆ ಇಲಾಖೆಗೆ ಸಂಪರ್ಕಿಸಿ ಸರ್ವೆ ಮಾಡಲು ತಿಳಿಸಿದ್ದು, ಆ ವೇಳೆಯಲ್ಲಿ 1ನೇ ಪ್ರತಿವಾದಿಗಳು ಕೂಡ ಯೋಜನೆ ಇಲಾಖೆಯವರು ನೋಟಿಸ್ ನೀಡಿದ್ದು, ಸದರಿ ನೋಟಿಸ್ ನೀಡುವುದರಿಂದ ವಾದಿಯದ ಆಸ್ತಿಯಲ್ಲಿ ಪಾಸ್ ನಂಬರ್ 4 ನಿರ್ಮಿಸುವುದಕ್ಕೆ ಬಡಾವಣೆ ನಕ್ಷೆಯಲ್ಲಿ ತೋರಿಸಿರುವುದು ಕಂಡು ಬಂದಿದ್ದು, ಸದರಿ ಸತ್ತಿನಲ್ಲಿ ಉದ್ಯಾನವನ ನಿರ್ಮಿಸಿದ್ದು ಪ್ರತಿವಾದಿಯಲ್ಲಿ ಯಾವುದೇ ಹಕ್ಕಿರುವುದು, ಆದ್ದರಿಂದ ಸ್ಥಳವನ್ನು ಪರಿಶೀಲಿಸಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ 85/1 ಹಾಗೂ 2 ಮತ್ತು 82 ಮೋಚನೆ ಮಾಡಿ ಸದರಿ ಬಡಾವಣೆ ನಕ್ಷೆಯಲ್ಲಿ ವಾದಿ ಆಸ್ತಿಯಲ್ಲಿ ತೋರಿಸಿರುವ ಉದ್ಯಾನ ನಂಬರ್ 4 ತೆಗೆಸುವಂತೆ ತಿಳಿಸಿದ್ದು, ಸದರಿ ನೋಟಿಸು ಮುಂದಿನ 15 ದಿನದಲ್ಲಿ ಪ್ರತಿವಾದಿ ವಾದಿ ಆಸ್ತಿಯಲ್ಲಿ ಉದ್ಯಾನ ನಂಬರ್ 4 ಬಡಾವಣೆ ನಕ್ಷೆಯಲ್ಲಿ ತೆಗೆದುಹಾಕದೆ ಮಾಡಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸೂಕ್ತ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳುವುದಾಗಿ ತಿಳಿಸಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ನಿಶಾನೆ B13 ವಾದಿ ದಾವಾ ಪೂರ್ವ ನೀಡಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. But this is so far as notice contemplated under section 125 is concerned, it has to be issued to the registrar of cooperative society, not to the society. Your lordship may kindly see section 125. Whereas the present notice exhibit B13 is issued to the society. No suit shall be instituted against a cooperative society or any of its officers in respect of any act touching the constitution, management, or the business of the society until the expiration of 2 months next after notice in writing has been delivered to the registrar or left at his office, stating the cause of action, the name, description, and place of residence of the plaintiff, and the relief which he claims. And the client shall contain a statement that such notice has been so delivered or left. There is no notice to the registrar of cooperative societies.
Yes.
Therefore, my submission to the notice exhibit P13 referred to by 13 the court. Is not a notice issued to the registrar of cooperative society. On the other hand, it is issued to the therefore, it does not comply with it. But the learned judge further gives a reason.
Yes.
That ಇಲ್ಲಿ ಇನ್ನೊಂದು ಗಮನಿಸಬೇಕಾದ
Order 7 Rule 11B.
Order 7. Notwithstanding that, it should have been independently considered. But Order 7 Rule 11B application merely because it is dismissed. It is open to the court to once again consider the question in the light of the arguments that would be advanced.
No, what did you allege in your application to Order 7 Rule 11D?
125.
125. Then say if that has reached its finality, find it to that effect it reached finality.
But in the High Court, I can once again re-agitate the matter.
But order passed in the year.
But there are
14.
there ought to be there must be some parameters for that. Not every orders not challenged earlier can be taken up in the appeal. Another case say there must be some rider. Otherwise, say
CPC
then it becomes total abuse of the process of the appeal.
Amendment application rejection or that can also be questioned in the regular appeal. That is what section 105.
What are the limitations of that? Whether all the orders passed by the trial court without being challenged can be agitated for the first time in the appeal.
All interlocutory orders can be agitated. All means not injunction like that.
Hagadre hitherto, what was the sanctity of the revision petition, civil revision petition? Section 115 CPC. ಅದೇ ಬೇಡ ಬೇಡಿತ್ತು ಅದನ್ನೆಲ್ಲ ಹಾಗೆ ಬಿಟ್ಟು ಆಗ್ಲಿ ಬಿಡಿ ಡಿಗ್ರಿ ಆಗ್ಲಿ ನೋಡೋಣ ಅಂತ ಆಮೇಲೆ ಮುಂದೋದ ನೋಡ್ಕೊಳ್ಳೋಣಂತೆ ಅಪೀಲ್ ನಲ್ಲಿ ಎಲ್ಲರೂ ಬಿಡಬಹುದಲ್ಲ.
Scope of section 115 is very limited. Even while dismissing revision petitions, this court used to observe that it is open to the party to challenge it in the regular appeal if ultimately this would be decided against the party.
ವಕೀಲರೇ ಅದು ನಿಮಗೂ ಗೊತ್ತಿದೆ ಹೆಚ್ಚಿನದು ಬರ್ತಾ 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 ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಸ್ಟ್ರಿಕ್ಟ್ ಆರ್ಡರ್ ನ ದಿಸ್ ಇಸ್ ಇದಮಿತ್ತಮ್ ದಿಸ್ ಈಸ್ ಡಿಕ್ಟಮ್ ಅನ್ನೋದಕ್ಕಿಂತಲೂ ಏನೋ ಸ್ವಲ್ಪ ಸ್ಕೋಪ್ ಕೊಟ್ಟು ವಕೀಲರನ್ನ ಪ್ಲೀಸ್ ಮಾಡೋ ಆಟಿಟ್ಯೂಡ್ ಜಾಸ್ತಿ ಆಗಿದೆ ಎಲ್ಲಾ ಕಡೆ. ಐ ಹ್ಯಾವ್ ಟು ಕನ್ಫೆಸ್ ದಟ್. ಹಾಗಾದಾಗ ಏನಾಗ್ತದೆ ಅದು ಅದೆಲ್ಲದು ಅಂತದ್ದು ಒಂದು ಅಬ್ಸರ್ವೇಷನ್ ನಮ್ಮಿಂದ ಬಂದ್ರೆ ಸಾಕು. ಇಟ್ ಆಕ್ಟ್ಸ್ ಆಸ್ ಎ ಪ್ರೆಸಿಡೆಂಟ್ ಟು ಆಲ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ಸ್. ಇಟ್ ಈಸ್ ಅ ರಾಂಗ್ ಪ್ರೆಸಿಡೆಂಟ್. ಅಂತದ್ದು ಒಂದು ಮಾಡಿದಾಗ ಎ ಸೀರೀಸ್ ಆಫ್ ಸಿಮಿಲರ್ ಆರ್ಡರ್ ವುಡ್ ಫಾಲೋ. Series of similar order would follow. Either if there is any such provision or the facility or the lenience in law giving it, or widening its scope and enlarging it only to serve the purpose of the petition before their lordship. And or maybe to shirk his responsibility. ನಾನು ಅದನ್ನೆಲ್ಲ ನೋಡ್ಬೇಕಾದ್ರೆ ಇನ್ನೂ ಜಾಸ್ತಿ ಓದಿ ಜಾಸ್ತಿ ಮೈಂಡ್ ಅಪ್ಲೈ ಮಾಡಿ ಬರೀಬೇಕು. ಸುಲಭ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ಅವರು ಹ್ಯಾಪಿ ಇವರು ಹ್ಯಾಪಿ ಇದೊಂದು ಅಬ್ಸರ್ವೇಷನ್ ಅಲ್ಲಿ ಬರೆಯಡಂತ.
Or 7 rule 11 D. Findings recorded by the trial court are then correct. The plaintiff has sued the suit against defendant number 1 to 3 for permanent injunction, restraining them from interfering their position and enjoyment of the social properties. The matter does not relate to the business of the defendant number 1 society. Therefore, issuance of the notice under section 125 of the ACS Act is not mandatory.
ಕೊಡಿಯದಾದ್ರು ಯಾವ ಡೇಟ್ ಇಂದ ತೆಗೆರಿ
24 to 2014. 24 to 2014. Which I have separate answer. ಇದು 22 4 ಇಲ್ಲ 24 2 24 2 4
But there are some decisions. This honorable court, but decision says that the mandatory is section 125 notice is necessary. But there are some decisions of this honorable court wherein they have taken the view that in respect of injunctions, this notice is not mandatory.
Actually, in the scope of 125, probably my 2 reported judgments are there. Was a few years back. When the notice is necessary, when it is not. The same point I had elaborated in my judgment. What is the scope of 125? When it can be said it touches the business, when it can be called it touches the management, when it called it touches the administration, and whether these kind of suits, whether they fall in any one of these 3 categories, until differentiate ಮಾಡಿದ್ದೇನೆ. Yes. Anything else?
Worships are remanding the matter. Only sufficient.
64,
1 minute, 1 minute is continuing. Yes.
Sorry, sir.
Lorships are remanding the matter.
No, I am not in the now. Say, no proposition, no sessions are there. I have heard you extensively, I have heard him extensively, I have heard him. The point. So let me decide
On merit.
what idea the God gives me, whether to remand or to dispose air itself on merit.
On merit.
One second, ಮುಗಿಸ್ಲಿ ರೀ ವಕೀಲ್ರೆ. ನೀವು ಸ್ವಲ್ಪ ಜೋರಾಗ್ಬೇಕು. ನಾನ್ ಮಾತಾಡ್ತಿದ್ದೇನೆ ಸ್ವಲ್ಪ ಇರ್ರಿ ಅಂತ. ನಾನ್ ಪದೇ ಪದೇ ಹೇಳ್ತಿದ್ದೇನೆ ಅವರಿಗೆ ಇರ್ರಿ ಅಂತ. ಹೇಳಿ.
I have read the paragraph 7 of the line.
Where
actually in the case of the plaintiff that in the approved plan, the part number 4 is shown in the suit schedule property. There is absolutely no evidence written by the plaintiff to establish that. But in order to succeed in the present suit, the plaintiff will have to establish that part number 4 is situated in survey in the suit schedule property. There is absolutely no evidence in that regard. But the defendant number 1 has admitted the title and possession of the suit schedule property. In that he has the she has the title over the suit schedule property. That is not disputed.
Your case may be that as per exhibit P11, the approved plan, if I remember correctly, exhibit P11 approved plan, part number 4, license survey number 82.
Yes.
His case is not that as per the approved plan, the park license survey number 85 or 85/1 or it does not lie in 82 is not his case. His case is that in the guise of that approved plan, instead of confining his so-called park number 4 in survey number 82, he is trespassing into my property in 85/1 and 85/2.
That is not the case, sir.
That is his case. Howdenri?
Paragraph 7
That is his case. ನಿಮ್ಮ ಪಾರ್ಕ್ 82 ನಲ್ಲಿ ಇಲ್ಲ ಅನ್ನೋದಲ್ಲ, ನಿಮ್ಮ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರಕಾರ ಇದೆ. ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರಕಾರ ಮಾಡ್ಕೊಂಡು 82 ನೊಳಗೆ ಇದ್ರೆ ನಾ ಸುಮ್ಮನೆ ಇರ್ತಿದ್ದೆ. ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ 82 ಅಂತ ತೋರಿಸಿ ಪ್ರಾಕ್ಟಿಕಲಿ 85 ಗೆ ಬರ್ತಾ ಇದ್ದೀರಿ. ಹಾಗೆ ಮಾಡಬೇಡಿ. ದಟ್ ಇಸ್ ಹಿಸ್ ಕೇಸ್.
Paragraph 7 of the plaintiff case.
ಕೊಡ್ರಿ plaintiff.
There is no land acquisition with respect to the suit schedule properties and the same are individual patta lands of the plaintiff. The plaintiff came to know that the first defendant had approached the second and third defendant for approval of their plan for first defendant. First defendant has wrongly given the details of the properties and without any land acquisition proceedings nor any rights in respect to the suit schedule property, illegally showing the portion of the suit schedule property as part number 4. Second phrase, book 1 in the alleged. This is legally showing the portion of the suit schedule properties as part number 4 of the plan number. At second phrase, book 1 in the alleged Rajiv Gandhi number plans. The said portion of the property shown as part number 4 is exclusively property of the plaintiff. Defendants are not conducted any survey or issued notice without looking into the title deeds nor the society has got rights over the property simple and mechanically sanctioned the layout plan in favor of the first defendant. The copy of the said layout plan is well. According to the plaintiff, there is a mistake in the sanctioned plan.
Para 12 of the plain parada, can we see? 10th line parada. That is the case of the explained in para 12 manner. Para 12.
if according to you, the part number 4 comes in survey number 82 only.
Yes.
Even under any stretch of imagination also, you are either encroached or attempting to encroach his property. Then, by the impugned judgment, you may not get affected, right?
No, not affected because what the plaintiff says is the park is in survey number in the suit schedule property. Park number 4 is.
What is the prayer he is sought for?
Prayer is injunction in respect of the lands owned by him. That is 85.
That is all. Yes,
No,
that is all. 885/1, 85/2.
But his case is park number 4 is also a part of the suit schedule property.
Is there any finding to that effect that say park number 4?
No finding is given with regard to that. Now, Lord,
then even say if he files a 39(2)(a) contempt against you for violation of the order of injunction,
no, he is virtually
no court can say that any judicial finding is there holding that part number 4 lies in survey number 85/1 or 85/2. Therefore, in the absence of any judicial finding that there is any interference by you with respect to survey number 85/1 or 85/2. However, since you are injected from interfering in the peaceful possession of 85/1, 85/2, which you never intending to do that, even say the alleged violation of the order or the contempt also cannot sustain.
By agreeing this vote, the court has accepted the case put forward by the plaintiff that park number 4 forms part of the suit schedule property. That is his case.
All that here, you generally you may be right, but once the suit is decreed, it does not mean that all what is said in the plaint has got the seal of the court, a seal of approval by the court. No.
But we have admitted that the plaintiff is the owner of survey number 85/1 and 85/2, totally measuring 1 acre 39 hectares. And we have also said that we are not interfering with his, we have never interfered with his, the possession of those 2 pieces of land.
Yes.
Now, my lord, he says by getting sanction for park number 4 by, from the planning authority. But we are saying that park number 4, which according to the plaintiff is situated in the suit schedule property, we are trying to interfere. Interference is only because of the plan, not there is no physical interference as such. Now, the plaintiff is not permitting the defendant to form the park there. Park number 4. The plaintiff can succeed in a suit like this for injunction only when the plaintiff establishes what he has pleaded in the plaint. According to the plaintiff, park number 4 is in the survey number 85/1 and 85/2. But unless the plaintiff establishes the case pleaded by him, he is not entitled to a decree for permanent injunction. But we are not being permitted to go to park number 4 at all. Now, that is why we could not develop that piece of land.
Yes.
The plaintiff virtually is challenging the approval granted by the planning authority to the plan. By saying like this, reading park number 4 is a part of suit schedule property.
DW1 himself has admitted that. There are no objection to decree this in favor of the plaintiff.
Kindly see the findings and recorded at page number 70, paper book 70. Yes, clearly.
EW1 cross examination, page number 40. Alway.
That is not what
ಪ್ರತಿಬಂಧಕಾಜ್ಞೆ ನೀಡಿದಲ್ಲಿ ಅದರಿಂದ ಪ್ರತಿವಾದಿಗೆ ಯಾವುದೇ ತೊಂದರೆ ಇಲ್ಲ ಎನ್ನುವುದು ನಿಜ.
beyond that stray sentence in the cross examination for the entire evidence we have to be
Anything else you want to add?
Plain pleadings, page 12.
ಈಗ ಅವ್ರು ಓದಿದ್ರಲ್ಲ
10th line ಅವರು ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾ ಇರೋದು ಏನು, ನಾನು ಪಾರ್ಕ್ ನ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಂತ
ಪ್ಯಾರಾ 8 ಅಲ್ಲಿ ಅದನ್ನೇ ಮಾಡಿದ್ದೀರಿ ಅಲ್ವಾ, ಈಗ ಅವ್ರು ಓದಿ ತೋರಿಸಿದ್ರಲ್ಲ. ಪ್ಯಾರಾ 8 ಅಲ್ಲಿ ನೀವು ನಿಮ್ಮ ಸರ್ವೆ ನಂಬರ್ ನಲ್ಲಿ ಅವ್ರು ಪಾರ್ಕ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದೀರಿ.
ಇದರಲ್ಲಿ trying to park the
ಅದ್ಯಾವುದು ಈಗ ನೋಡಲ್ಲ, ಈಗ ನೋಡುವ ಅವಶ್ಯಕತೆ ಬರಲ್ಲ.
But if para 12 minute in my pleadings, they are trying to interfere with my position and trying to encroach the portion of the social property. That is my allegation. Therefore, I filed a suit for injunction. So far as the section 64 of the BD Act, they have not filed any appeal. They have not challenged the findings recorded by the trial court. Now they have contended that section 64 is not issued within the statutory period.
Is it not a question of law? Maintainability or non-compliance of a statutory requirement?
This is a question of law.
The court can consider his oral argument. Learned counsels from both sides present. Heard arguments from learned counsel. Learned counsels for respondents. The 1 and 2 in full, and also reply argument. Judgment result.
So far as they are filed, no.
Stated
that they are ready to remand the matter to the trial court.
Memo is not before the court now. Richmond.
One submission with your lordship's kind leave.
Yes, please.
May I disturb your lordship?
No, proceed, please.
Serial number 74. I am for the respondent. The suit for declaration and possession decreed, and it is stayed now. That's pending. Some date. Convey to your lordship some date.
ಬೆಳಗ್ಗೆ ಯಾರು ನಿಮ್ ಜೂನಿಯರ್ ಅಂತ ಹೇಳಿ ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೊಂಡ್ರಲ್ರಿ ಸಮ್ ಲೇಡಿ.
ಜೂನಿಯರ್ ಹತ್ರ?
ಹೌದು.
ಐ ಆಮ್ ಸಾರಿ ದೆನ್ ಇಫ್ ಇಟ್ ಇಸ್ ಆಲ್ರೆಡಿ ಅಡ್ಜರ್ಡ್ ನೋಡಿ.
ಇದರಲ್ಲಿ 74 ಅಲ್ಲ, 74 ನಲ್ಲಿ ಆಕೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು.
74 ಇವರು ದೇಶಪಾಂಡೆ ಅವರು, ಅಮಿತ್ ದೇಶಪಾಂಡೆ ಅವರು.
ಅಮಿತ್ ದೇಶಪಾಂಡೆ ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರು. ಆಗಿದೆಯಾ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಅಪ್ಲೋಡ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಡೇಟ್ ಹೋಗಿದ್ರೆ ಅದನ್ನ ಐ ವಿಲ್ ನಾಟ್ ಡಿಸ್ಟರ್ಬ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್.
ಇಲ್ಲ, she was a junior counsel, she was a bit confused.
Some date
ಅದೆಲ್ಲ ಮೂವ್ ಮಾಡಿದ್ರು, ಎಲ್ಲ ಮಾಡಿದ್ರು. ಆಮೇಲೆ after some time she interfered and said that she was sorry, she could not able to make proper submission. She wrongly mentioned serial number. Of the case law ಅಂತೆಲ್ಲ ಹೇಳಿದ್ರು. By that time sufficient time had lapsed and another stenographer had come.
ತಮಗೆ ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್ ಯಾವ್ದಾರು?
ಆಮೇಲೆ ಬಂದು ಸೀರಿಯಲ್ ನಂಬರ್ 75 ಅಂದ್ರು ನೋಡಿ ಆ ಲೇಡಿ. ಸ್ವಲ್ಪ ಹೊತ್ತು ಬಿಟ್ಟು ಬೇರೆ ಮ್ಯಾಟರ್ ನಡೀತಿರ್ಬೇಕಾದ್ರೆ ಇಂಟರ್ಫಿಯರ್ ಆದ್ರ ಆಕೆ. ಅದು ನೋಡಿ ಅದ್ರಲ್ಲಿ 74 ಅಲ್ಲಿ ಅಡ್ಜರ್ನ್ ಅಂತ ಅಷ್ಟೇ ಇದ್ರೆ ಅದನ್ನ ಅದ್ರ ಜೊತೆಗೆ ಇಷ್ಟು ಮ್ಯಾಟರ್ ಆನ್ 17/7. 17 ಒಂದು ಕೊಟ್ಟಿರ್ಬೇಕಲ್ಲ ನಿಮಗೆ?
ಹೌದು, ಒಂದು ಕೊಟ್ಟಿದ್ದೀರಿ.
ಒಂದು ಕೊಟ್ಟಿದ್ದೇನೆ 17. ಹಾಗಾದ್ರೆ 17 ಬೇಡ, 18 ಹಾಕುವ ಇದನ್ನ.
ಆಗ್ಬೋದು 18.
18/7 ಅಂತ ಹಾಕೊಳ್ಳಿ.
Number 71.
71 ನಾ?
71. Only extend the entry line.
ಯಾರು ಮೂವ್ ಮಾಡ್ಲಿಲ್ವಾ? Who appears for the appellant in
I have
this?
to bear.
Why should I extend the interim order?
That's right.
No, I will not extend the interim order because this matter was called this morning. Nobody was there. Matter case ಕರೆದಾಗ ಇಲ್ಲದಂಗ ಆಮೇಲೆ ಕೋರ್ಟ್ ಟೈಮ್ ಮುಗಿದ್ರ ಮೇಲೆ ಬಂದು ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ರಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ರಿ ಅಂದ್ರೆ ಬೈಸ್ಕಳಿ ಸೀನಿಯರ್ ಹತ್ರ ಕೇಸಲ್ಲಿ ಇರ್ಬೇಕಮ್ಮ, ಕೇಸ್ ಕರೆದ ಕೋರ್ಟ್ ಇಂದ ಹೊರಗಡೆ ಹೋಗಬಾರ್ದು ಅಂದ್ರೆ ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ ನೋಡ್ತಾ ಹೋಗ್ತೀರಿ. ಅವ್ರು ಬಂದು ಅಥಾರಿಟೇಟಿವ್ಲಿ ಕೇಳ್ತಾರೆ, ಕೈಂಡ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ದ ಇಂಟರ್ವ್ಯೂ ಆರ್ಡರ್. ಇಟ್ ಡಸಂಟ್ ಡಿಸರ್ವ್.
I have not authoritatively sacked this.
ನೋಡಿ,
Only requested.
ನನ್ನ ಪಿಯರ್
Sorry.
called again in the afternoon. Learned counsel for the appellant and you are for K-8R. K-8R and respondent number 2. K-8R and LRs of respondent number 2 are physically present. Since the court time is over, the matter could not be proceeded further. This matter, the week after next, the interim order granted earlier is extended for 3 weeks from today.
Much of.
ಡೇಟ್ ಅಲ್ಲಿ ಅವರೇ ಮೂವ್ ಮಾಡಿಕೊಂಡು ಬರ್ತಾರೆ. ನಾನು ಅಂಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಂತ ಕೊಟ್ಟಿಲ್ಲ, ನಾನು ಕೊಡಲ್ಲ ಅಂತ ಮ್ಯಾಟರ್ಗಳಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಂದ್ರೆ 5 ವರ್ಷ ಫೈಲ್ ಹೊರಗೆ ಬರಲ್ಲ. ಹಾಗಾಗಿ ನಾನು ಬರೀ 3 ವಾರ 2 ವಾರ ಅಂತೀನಿ. ಅವಾಗ ಅವರೇ ಮೆಮೋ ಫಾರ್ಮ್ ಪೋಸ್ಟ್ ಮೂವ್ ಮಾಡಿ ಬರ್ತಾರೆ. ಅವಾಗ ಅಟ್ಲೀಸ್ಟ್ ಏನ್ ಫೈಲ್ ಅಂತ ಓದ್ಕೊಂಡು ಬರ್ತಾರೆ. ಸುಮ್ನೆ ನಾನು ಡೇಟ್ ಕೊಟ್ಟೆ ಅಂದ್ರೆ ಅವತ್ತಿನ ದಿವಸ ಬೆಳಗ್ಗೆ 10:00 ಜೂನಿಯರ್ ಬಂದು ಸಾಹೇಬ್ರೆ ಹೈಕೋರ್ಟ್ಗೆ ಹೋಗೋ ಟೈಮ್ ಆಯ್ತು ಬರ್ರಿ ಅನ್ನೋವರೆಗೆ ಅವ್ರು ನೋಡಲ್ಲ. And 3 weeks now 4 weeks ಮಾಡಿ list the matter on 2/8. Yes.